In view of the aforesaid facts and circumstances, this court is of the unhesitating opinion that a case for interference is made out in the instant petition. It is accordingly directed that the case of the petitioner be considered for promotion to the rank of senior grade 1 ACS by convening a review DPC for the vacancies arising in the year 2011. The aforesaid direction is, however, subject to the condition that the same only pertains to a consideration of the case of the petitioner for such promotion, wherein the criteria laid down in Rule 12, namely merit with due regard to seniority, is required to be followed meticulously. Such review DPC is to be convened within a period of 60 days from today, and in the event the petitioner is found to be eligible for promotion to any of the vacancies of the year 2011, he will be entitled to all the notional benefits, including a proper fitment in the pensionary benefits which are being received by the petitioner, and such benefits have to be worked out by treating the petitioner to have retired from the promotional post of grade 1 ACS. Petition accordingly stands allowed.
Made with your lordship. Lordship with the consent of the other
Just,
side. And
just a minute, just a minute. Yes.
Lordship, item numbers 19, 20, and 21. Lordship, Mr. Deenath is appearing on behalf of the state. He is not well, Lordship. Let the matter come up in the next week.
Review matters.
Review matters, Lordship.
Who's for the other side?
Let it be on 7th of September. You know.
Oh, those matters.
Yes.
Social welfare.
Social welfare.
Oh, he's not well. Otherwise, we wanted to finish up this matter.
Lordship suffering from conjunctivitis, Lordship.
But no, it's okay. When do you want?
On 7th of September.
This court has been informed that Sri Deenath, the senior government advocate, appearing for the state, which is the review applicant, is unwell. As agreed to by the parties based on
7th of September.
7th September.
Lordship.
This is 18, 19, 20, and 21.
Lordship.
Okay.
Public.
Yes,
But item number 5 and 6, Lordship. But we are not pressing this matter. Lordship.
different petitioners.
My lord.
Sri M. Khan, Learned Counsel for the petitioners, submit that he has instructions not to press this writ. There are also heard G. T.C. Chutia, Learned Additional Senior Government Assam, represent accordingly stands dismissed as not pressed. Yes.
Ma'am, I would like to mention one listing of the case. My lord, compulsory appointment case, my lord. April it is listed and instruction is waiting, my lord. So it may be
When?
at any day that will come.
The next Monday?
Next.
Next Monday is the holiday. Friday.
God bless.
We have Pedro Lordship. Lordship, I beg to mention item number 26. Supplemented is
Yes.
Lordship, my learned senior is out of station.
This is this is the bench one matter. You go before the appropriate bench.
26.
It cannot be given. It's not a partner matter, madam.
Lordship heard the matter?
Maybe we have heard, but we cannot remember.
Yes, sir.
Don't make this kind of submission.
No, not
before
part,
another
I am
court.
partnered, Lordship, that is hard
Don't make this
substantially.
kind of submission in another court that it is heard.
That is hard substantially, Lordship,
Doesn't matter.
not partnered.
You cannot do all these things at the same time. You
My-
expect us to do bench one, bench two, bench three at the same time. Not possible. If it's a partner matter, matter is different. It's not a partner matter. Go before the appropriate bench. So this is a wrong submission. We have seen this. Why should a bench one matter come here?
This is second appeal, Lordship.
That is it. We are bench three now.
Yes, Lordship.
We'll go before the appropriate bench.
Yes, Lordship.
So it appears that this matter has been listed by an order dated 24/8/2023, the said order was passed on the submission that the matter was heard by this court. It is made clear that unless the matter is part heard, there is no requirement to place the matter before this court. full stop. Before is put which presently is entrusted with civil bench free matters, full stop. Registry to release this case before the appropriate bench.
Obliged.
Right, sir.
Lordship. Item number 22, Lordship.
Yes.
I've been requested by the other side, Lordship, that to fix the matter on 19th or 20th of September.
Some difficulty today
He is not coming today.
that he is in person.
He is in person, Lord.
His name is also not being sure.
Yes, Lordship.
We talk about the Ranjit submit that the
Mr.
Respondent-
G.D. Dhiman.
respondent is represented by by the proprietor who is appearing in person, and he has got some difficulties today. Put up para. When
19th or 20th of September.
Please. As requested, please on 19th of September.
Lordship, there is an interim order that may continue.
19th of September. It is 19th. Let it be 20th of September.
Lordship,
20.
Lord.
20th of September. Registry to. Why his name is reflected is the form.
Lordship.
Interim order passed early. Continue till the next date.
Deeply obliged.
May I please, Lordship? Therefore, listing Lordship, one motion matter, Lordship. Matter regarding Lordship, suspension matter, Lordship.
Suspension.
Yes, Lordship.
Filed or not?
Yes, I have filed already.
21.
Friday, Lordship.
May please, your Lordship. Lordship, I beg to mention for listing of the matter for admission, Lordship.
Matter
On
which
Friday.
year?
23, Lordship. Lordship, the matter relates to downgrading of the petitioner's Lordship. Similar matters have been disposed of by this honorable court, Lordship. However, the matter was only listed for motion in the month of February, Lordship. Thereafter, it has not been listed.
We'll have it next week. There are
Lordship.
holidays. Towards the last part of next week.
Eighth,
We have been on 7th or 8th. We give it 8th of September.
Obliged, Lordship.
May please, your Lordship, I beg to mention listing of this matter for admission column
Matter of which year?
2019.
Give it on the same date. 8th of September.
Lordship.
Yes.
With the consent of the other side, I beg to mention item number 13, Lordship.
1-3.
Yes, Lordship.
Yes.
Mr. K.K. Mohanto is not well, Lordship. Matter may be fixed for any other day.
You for the APC.
Lordship, respondent number 7.
APC.
No, Lordship.
You for whom?
Number 7, Lordship.
7. This court has been informed that Sri K.K. Mohantolan, senior counsel for the petitioner, is unwell. Para, please after 2 weeks. Item 30.
Much obliged.
Yes. Yes, what is it?
That matter relates to sexual harassment at workplace matter.
Yes, yes.
Let me have some instructions.
You have the instructions.
No, I have to take instructions. Let it
Get
come
the
Friday.
instructions. We issue a short notice then.
Well,
And but this matters, there's nothing to see. It's not a dispute at all. You follow the mandate of the law. Your person has to be a woman, has to be a woman. And you cannot just dilly-dally a matter of sexual harassment.
Let
This
it
is
come
a
out.
serious allegation. You are at the stage of allegation, it may not be correct, but you have to make an inquiry.
there was no internal complaint committee
Yes.
earlier. Only after
Heard, Sri N.K. Kolita, and a counsel for the petition, who is aggrieved by the inaction of the respondent authority to take steps on her complaint lodged under the
Complaint was lodged on
sexual harassment of women at workplace, पूरा लिख देना, within bracket, prevention, prohibition and redress, bracket code act 2013. Full stop. The complaint, the petitioner who is engaged as a proofreader in the Assam Textbook Production and Publication Corporation Limited
Yeah.
has made certain allegations against this phone number,
Page number,
this phone number, this phone number 5
management, respondent number 5,
Five.
private respondent,
on
formal complaint.
2/2/2023. Full stop. It has been alleged there was no internal complaint committee, and in any case, no action was taken. Full stop. It was only pursuant to filing of an earlier writ petition by the petitioner, being WPC 1890 of 2023, that an internal complaint committee was constituted to inquire into the complaint on 3/4/2020. Whereafter, no tangible action has been seen. Issue notice returnable on on 25th of September. Three E. Gogoi. No, this is elementary education board. Anyone elementary? Any standing council? Just give the name elementary. P. Bora. P. Bora is there.
P. Bora, madam.
P. Bora, PK Bora, P. Bora. P. Bora, standing council elementary education. Accept notice on behalf of respondent number 1. Whereas
2, 3, 4, madam.
whereas the respondent numbers 2, 3, and 4 are whereas notice for respondent numbers 2, 3, and 4 is accepted by the D. Gogoi, the learned standing council. Full stop. That extra copies of the petition served upon the learned council for the respondent. That steps be taken for service of note upon the respondent number 5 by registered post. Steps within 2 days. Why haven't you made the corporation a part? Don't make this basic errors in
respondent number 1, madam.
what point is the corporation.
So, madam, corporation, madam, the managing director has been made party.
The managing director of the corporation.
No, madam.
Don't make that substance Mr. Kolisa at this stage. The MD is a part. Corporation is the legal entity. Make this same mistake again and again. Yes, next.
All right.
May it please your lordship. My lord, the last occasion, my lord, it turned out that some of the petitioners have expired, my lord. But I tried to take instruction whether the legal heirs would like to implead, my lord. I contacted the petitioner number 1, my lord. Nobody is coming forward. And as per my instructions, my lord, petitioner number 6, 7, and 11 have expired. Since none has come forward for substitution, their names may be stuck off. And my lord, the matter may be heard, my lord, finally. Here. Okay. What is the matter? My lord, this matter relates to non-payment of gratuity, my lord. The petitioners. By whom?
By
The society, my lord. The petitioners are all retired employees of, my lord, Jyoti Chitravan Film Studio Society. Mr. Sharma, for whom?
Society, lord. That's point number
My lord, it's a government registered society The petitioners have retired from the society, and as per the Payment of Gratuity Act, my lord, the petitioners are entitled to receive gratuity, my lord. Now, if your lordship, how many of you are there? Please, my lord, 11 have approached this honorable court, my lord. There will be many more, but 11 have approached. Out of whom, my lord, 6, 7, and 11 has number 6, number 7, and number 11 has expired, my lord. So it will remain, you are pressing for the rest of the petition. Rest of the petition. They are the employees of Jyoti Chitravan. Jyoti Chitravan Film Studio Society. Jyoti Chitravan Film Studio Society, my lord. It's a government society. It's a government society, my lord. Where are you making? Yes, my lord. If your lordship takes up my affidavit filed on 15/9/2021, my lord. Additional affidavit. Additional affidavit, my lord. Lordship. Fifteen 9/2021. Who has filed? Deponent. Deponent. Deponent is the petitioner number 1. Name. Okon Chandra Gogoi. Date of filing? 15th of September 2021. Madam, that has not been paginated actually. Doesn't matter. Yes, but of this particular affidavit. Yes. If your lordship peruses annexer E page 12, my lord. Yes. Here is a certificate issued by Commissioner and Secretary, my lord, Department of Cultural Affairs. I'm reading out, to whom it may concern. This is to certify that Jyoti Chitravan Film Studio Society is a government registered society functioning under the Department of Cultural Affairs, Government of Assam, with registration number so and so. The society has been receiving regular grants date from the Government of Assam. Okay. Now, in the next page, my line, Annexer F, my lord, the control of the government is FRN, my lord. The control of the government. My lord, this is a communication by the Director of Cultural Affairs to the Principal Secretary to the Government of Assam. And my lord, this is a regarding demand of fund for running of affairs of granting it, my lord. In 2012, after the registration file, my lord. I have the honor to submit here with a proposal amounting to rupees 70 lakh only grant in it to Jyoti Chitravan Society for employee salary to Jyoti Chitravan during the year 2012-13, a photocopy so and so. Yes. Even it comes under the purview of the on earlier occasion, on writ appeal was also decided by this honorable court. That copy of the particular writ appeal is in page 14, my lord. 1/4, my lord. Annexer G. If your lordship peruses Virendra Kumar Das versus Jyoti Chitravan Film Studio. Yes. So this is no more in my lord dispute that. And writ appeal. Writ appeal, in the writ appeal. And the specific finding, my lord, will find it page 16, my lord. Page 16. Page 16, first paragraph, second paragraph, my lord. Though the respondent society, which is a state government control body, is not represented today. So it's a state government. Paragraph? Paragraph, second paragraph, my lord. Though the respondent society, which is a state government. Which page? My lord, page 16. Next page. Page 16 of the order. So my lord, objection was raised by the respondents in their affidavit that this society may not be amenable to the writ jurisdiction. No, we are not on the writ part. Lordship. Even if it's amenable to the writ jurisdiction, Lordship. Your claim, Lordship, under the Gratuity Act, Lordship, how to justify? Yes, Lordship. My lord, if your lordship. First hurdle, we may not be too rigid. Lordship. We may hold that writ jurisdiction, and at this stage of final hearing, we may not go to the aspect of maintenance. But the substantive relief which you are seeking, namely gratuity, has to flow from the Gratuity Act. Yes, true, my lord. Now, this query was once raised by the Honorable Court, and if your lordship peruses the order dated 25/2/2020, my lord, that I have made a part of the, it is annexed to the affidavit itself. Lordship may read it from the affidavit. My additional affidavit, page 10, my lord. This particular order was passed in this proceedings itself, my lord. 25/2/2020, my lord. The learned counsel for the petitioner contends that the petitioners herein were former employees of Jyoti Chitraban Film Studio Society. By this writ petition, a claim is made for payment of gratuity upon their superannuation from service. Payment of gratuity is provided under the Payment of Gratuity Act 1972, Section 1(3) of the Act provides as follows. It shall apply to every factory, mine, oil field, plantation, port, and railway company. This order was not challenged. Lordship? This order was not challenged. Not challenged. And my lord, I'm relevant portion is for our case, my lord. C, my lord. For the petitioners, C will be relevant, my lord. C? C of this particular order, if your lordship peruses clause C actually. I will not go into the aspect now, since the court has already said that this society would come with the meaning of the act. Whether to come under the meaning, whether notification was there or not by the central government, that a query was raised upon me. We did some research, my lord. Finally, we could lay hands on the notification, my lord. The statutory order, my lord. That way also we have brought on record, on the basis of which societies have been brought under the Payment of Gratuity Act. This point has not been decided. No, this point has not been decided. I'm taking to your lordship to the our result of our endeavors. We thought that this was decided. No, my lord, this was not decided. Then what did you do there? My lord, now annexure 8 of the same affidavit, page 70. Yes. My lord, this is a gazette notification for the government of India dated September 6, 1997, my lord. Now page 18, my lord. Page 8, next page of the. Yes. My lord, SO, the right hand side bottom, my lord, SO 2218. In exercise of the powers conferred by clause C of subsection 3 of section 1 of the Payment of Gratuity Act 1972, the central government hereby specifies the trust or societies registered under the Societies Registration Act 1860, sorry, or under any other law with respect to the societies for the time being in force in any state in which 10 or more persons are employed or were employed for wages on any day of the preceding 12 months as a class of establishment to which the state act shall apply with effect from the date of publication of this notification in the official gazette. So now the lordship, the petitioners become entitled. This is the simple case. And the plea taken by the society is that they are in a fund crunch situation. If the government is directed to provide the fund, they are willing to pay. And on principle, you are not objecting.
On principle regarding the amenability of this matter in the rate code, I have got nothing to submit because yes, this is basically run by the government, this site. On the second aspect regarding gratuity, now for the gratuity, yes, there is a notification that brings them under the purview of the Gratuity Act. But then our society should also have a gratuity fund. A gratuity fund, as I could
You're
understand,
for the society.
for society.
There is no,
Yes. The categorical stand taken in the affidavit if I may directly take your lordship to the affidavit.
Yes.
Our affidavit was filed in 1/12/2011. Respondent number 2 and 3, Itimoni Coupon. Because the Act provides that for a gratuity fund, there has to be an insurance policy that we'll have to buy, premium has to be paid under the LIC. That is how the fund is created. But there is nothing of that sort for a society. So, practically speaking, even if there is an order, how do I pay? Because there is no fund, or there is no existence of a gratuity fund for us. We'll also will kindly come to that affidavit. Itimoni Coupon,
yes, yes.
2011. Yes. We also will directly come to paragraph 10, page 5. This was that.
R2 and 3.
Yes, Lord. R2 and 3, page 5, paragraph 10.
Yes.
Yes. The deponent states that the area DA of all the petitioners were already paid to them. So far as gratuity and leave encashment is concerned, there is no such provision in the society for paying the same, except 6 months of salary is paid to them as a retirement benefit. So this is what has been followed. And this has been corroborated by the affidavit filed by the Cultural Affairs Joint Secretary on 12/3/2012. Affidavit by Respondent number 5, Joint Secretary, Cultural Affairs Department.
R.
R5, Lordship. Joint Secretary, Cultural Affairs.
Filed on 6 March.
Yes, Lord. 12/3 is
Faizul Hussain.
Faizul Hussain. Yes, Lordship. Paragraph number 6. Paragraph 6,
Page.
page 3, Lordship.
Yes.
That with regard to statement made in paragraph 6 of the petition, the deponent begs to state that there is no provision for payment of gratuity or leave encashment in Jyoti Chitravansh society. So the practical position or difficulty that we are in, yes, in principle we will agree. They are entitled, maybe under this present notification of 1997. But then how do I pay? That is the question now. I am not against them. I'm not averse to their prayer. But as a society, we have never been into this kind of a apparatus. The apparatus was never in place. Yes, it is amenable in jurisdiction, but we are running as a society. And another aspect of the matter is we were always a fund trans society. There is even deficit.
No fund part, you may not we have accepted your plea. There is no fund.
No fund.
How
Or-
do you implement? But on principle,
Yes, sir.
what is your take on their claim for being employees of a society, which is there is no dispute that it's a government run society.
In view of the notification as was immediate just now placed, societies now come under the gratuity.
Because
Act.
there is no dispute with regard to number of employees, more than 10.
That's not a dispute.
So the application of gratuity act, there should not be any dispute. The only problem is how do you gather the funds, how do you pay?
Because my clear instruction is what my instruction I have got is what they are claiming to is not something that we are totally averse. Our problem is this.
Anything else? Mr.
And we have been always receiving deficit grantinage from them.
It is, so far, this affidavit says, my lord, that's for number 5. But there is no provision, my lord. This is, my lord, this paragraph 6 was just stated.
Yes.
The deponent begs to state there is no provision for payment of gratuity or leave encouragement as duty upon the society. This is a fact that the husband of the petitioner number 7, 12 were also employees of duty upon under the response number 2. The petitioner number 7, 10, 11, 12 had been paid 6 months.
Just a minute, just a minute. All the petitioners are not the employees. There, some of them are
Some of their
legal heirs, legal heirs. Oh, yes,
salary under Rule 32, clause 2 of the AFR Rule 1953 in view of other pensionary benefits. The other pensionary benefits in lieu of other pensionary benefits, they have been paid the 6 months salary. And the petitioner number 8 and 9 had not received any benefit as the decision of paying 6 months salary on attaining the age of superannuation was not involved during their period. However, the dependent of late Munindo Suduri and late Modon Kakoti wife were given appointment in the society on compulsory account. So 2 persons were given on compulsory account, but they were not paid salary. So there is no provision placed in for the gratuity. So how
is the society running, isn't it?
yes, society is there, but I don't know, my lord, it is a.
My lord, if I have heard, my lord, that the situation is much improved since filing of the affidavit. And how many such employees, petitioner, not petitioners, similarly placed persons are there? Like, my lord, many, there are many, quite. I cannot get the exact number right now, but they have not come to the. My lord, actually, everybody were waiting for some outcome in this petition. If some directions are given, then others will be also come. Should we have, can something be done?
No, my lord, let me have a, my lord, instruction.
To 12 matter.
Yeah, 12 minutes, but I would stop here, my lord. I am handicapped, my lord. I have no file today, my lord.
Now we'll close this matter.
I am taking the
We'll
second
close
file.
this matter for judgment. In fact, we wanted to dictate this judgment today. We'll close the matter and you can come instruct, or we can have it one. We can have it day after tomorrow.
Day after tomorrow, my lord.
Day after tomorrow.
At least I will.
Some of the list matter will come. To
Yes, yes, yes.
And for practical, all practical purposes, the hearing is complete. We'll only take some.
Yes, yes.
Yes, any case law.
Case law, my lord, only on the maintainability ground, I am supported by Bombay.
On funds.
Funds, my lord, well, state should provide, my lord, it's a
Case law.
My lord, gratuity should be paid, my lord, there are some.
Not on gratuity. Case laws on how the state has to make available funds for a society of this kind. There are direct case laws.
I will search, man.
What? You knew that this is the only, it's not a different tough case at all. They are not even objecting in principle.
My lord,
You pick up a handle to the court. There are direct decisions.
my lord,
State has to step in, make available funds.
my lord,
We'll have day after tomorrow.
one decision is there, my lord, Supreme Court, my lord.
Yes, Supreme Court. What?
My lord, this Angadi Mukta Sadguru Sri, my lord.
Those are on the maintaining.
And again, this
Not
is also
on-
related to
yeah,
the
no, not-
providing of funds, my lord, by the state.
Don't fight those. They are not on those. They are not even objecting on the amenable part.
I will search, my lord. Some on gratuity, there are some that state should.
Not only gratuity, anything which is entitled to by a retired employee of an organization which is managed by the state has to step in case of fund run. There are the direct issue. Third, the chief of the council for the petitioners who at the outset submit that petitioner number 6, 7, and 11 have passed away, and in spite of his efforts, no application has filed for impeding the legal heir to substitute the deceased petitioner. Full stop. According to the name of the petitioner numbers 6, 7, and 11 are struck off. Full stop. The matter relates to a claim for gratuity and leave encashment of the petitioners who are either employees, either retired employees of Jyoti Chitraban Film Studio Society or the legal heirs of certain retired employees. It is submitted that the Sage Society is fully controlled by the government and survives on the grants made by the government. Full stop. The Learned Council has also referred to a Gazette notification dated 6/9/1997, wherein there is a specific whereby it has been specifically laid down that establishment having 10 or more persons like that of respondent society, the Gratuity Act would be applicable. Full stop. Para. Sri Sharma A. Sharma, Learned Council, appearing for the society, fairly submits that he is not raising any objection with regard to maintainability of the certification, as the society in question is controlled by the state. However, with regard to the claim, he submits that the society is having fund transfer, and therefore, in absence of any funds under the head of gratuity, it is not possible for this society to release any amount under gratuity and leave encashment. He has also drawn the attention of the court to the affidavit in opposition dated 1/12/2011, filed on behalf of the respondents 2 and 3, wherein in paragraph 10 thereof, it has been stated that there is no provision for payment of gratuity or leave encashment in this society. The reference has also been made to the affidavit in opposition filed by the respondent number 5 on 15/3/2012, wherein a similar statement has been made regarding absence of any provision for payment of gratuity. The C.C. Chutia, the learned additional senior advocate, appearing for the state response, while endorsing the submission of the Sharma, has contended that in absence of any provision for payment of the public leave encashment, the petitioner may not be entitled to any relief. The after considering the rival submission and there being no dispute to the fact regarding the maintainability regarding the applicability of the Gratuity Act by virtue of Gazette notification dated 6/9/1997, the claim made by the petitioners cannot be said without any basis. The question therefore arises is how to deal with the position wherein, the society has pleaded that there is one grudge. The duty of the learned state council, however, submit that he may grant sometime to obtain instructions that considering that considering subject matter of petition and also the fact that the same is pending since the year 2012, a short adjournment run. Directly testing of the matter on
31st.
after
31st.
or first
Final.
Thursday or Friday.
Friday. Better.
Friday immediately after the moon.
Yes, yes.
Place this matter in under the column within first column. Are anything by you? They are any consequence, but also endorse the submission of the Turkey and has additionally contended that the petitioner or the employees are not government service. Gratuity is only entitled to government service. Gratuity. Don't mix it up.
Claim is for gratuity only.
No, that we have.
Now they're
Limited to gratuity only they claim.
endorses and submits that there is no provision. And then endorse. Friday we will dispose this up. We have already reiterated this order and find us some solution. You come up with case laws.
Lordship, while observing in the order, have stated leave encashment also.
No, their claim. We have not said it.
Yes, but now they are not claiming leave encashment. It's only limited to gratuity.
This is not the final order.
Yes.
We are only going by the pleadings.
Yes,
In the thing will say that it may be confined only to gratuity.
to gratuity. Oblige,
Just
oblige.
remind this.
Yes, Lordship, I will.
May I please, your Lordship? Lordship, this petition is filed for challenging the penalty of compulsory retirement on the petitioner by letter dated and annexure 5, Lordship. Page 25 is the impugn order, Lordship.
You are an employee.
I was the employee, Lordship. I was given compulsory
Let
retirement,
us have the fact.
Lordship. Lordship, page 13 was search sheet was issued on me on 21st February
Just a minute,
2009.
just a minute. Who are you?
Lordship,
You were
I was working as an officer scale 1 at Pakjyotish Gaolia Bank, Lordship. Now it's the Assam Government Vikas Bank.
scale one officer. Sir. Of Prakjyotish Gaolia Bank.
Erstwhile Pakjyotish Gaolia Bank, now Assam Government Vikas Bank.
Okay.
In 2006, Lordship,
When did you join?
and I joined in the year
1990.
1990, Lordship.
Okay. Then
And in the year 2006, that Pakjyotish Gaolia Bank merged with that amalgamated with Assam Government Vikas Bank.
yes, okay.
In 2009, Lordship, at Annexure 1, I was served on third seat, Lordship,
You were, what was the capacity?
as the officer scale 1, Lordship.
Same
Same
capacity.
scale, Lordship.
Charge memo file. Charge
Charge
memo
memo.
submitted.
Sajmo, Lordship, Annexure 5, Lordship, and page 13, Lordship.
22 2
2, Lord, 21 2.
1 2. Or 20
21 to Lordship, page 13 Lordship,
13.
1 Lordship.
Twenty-one
21 Lordship,
to 2020, page 13.
page 13. As many as Lordship, 5 charges were leveled against me, Lordship.
5 charges.
5
What?
charges, Lordship. Alleging Lordship, illegal withdrawal of money, Lordship, from the accounts of my customer. And this is the main charge, Lordship, and also not maintaining that properly cash book and diverting the fund one LAD head to GL head and etc. Lordship. But problem is that, Lordship, that petitioner, Lordship, has filed reply against that in annexure to page 16, but very cryptic and without denying any charges.
Page?
Lordship. Page 16, Lordship.
It is a written statement of defense.
It was the only reply was filed, Lordship, by my client. Nothing any denial.
You admitted this. That is why Mr. Dutta is lying low.
Lordship.
Nothing to defend.
But annexure, Lordship, page 18, that impugn
He must have taken the advice of Mr. Dutta.
Lordship.
Make things
Annexure
easy. Make things
18,
easy for us.
Uh.
Admit everything.
annexure 18, Lordship, enquiry report was served on me, Lordship. Page 18, Lordship.
So is the inquiry required at all?
Actually, after
Inquiry is required when you dispute.
no, Lordship, not required.
That case, Mr. Dutta, we thought there's something here.
That's why, Lordship, when I turn to page 16, I have lowered down my voice.
What explanation have you given? Why did you write it?
Lordship, in Lordship, inquiry,
Were you forced to write this?
no,
Have
Lordship.
you made out any case?
In appeal, Lordship, while submitting appeal, he took up a defense that at that point of time he served in a Michigan port area in Kukurajar, Nalbari area, and he was forced to take some money, Lordship.
No, that is your explanation. Now, what's the explanation of giving this kind of written statement of defense?
No, Lordship, it was I
Nothing.
was not consulted at that point of time.
No, while drafting the written statement, could have said something. that
Yes.
W was given by
Yes.
mistaken
Yes.
understanding.
Uh,
Have you said
Initially, I refused, Lordship, to take up my brief, but after some, he took ask me.
inquiry done?
But Lordship, enquiry report, page 19, the only argument before Lordship, arguable point before Lordship, that in enquiry report, Lordship, it is not an enquiry report as such. Lordship. If you, Lordship, turn to page 20, how that enquiry report has been drafted. See, Lordship, in the first column, the sergeant brief. In second column, there is PO's brief. Third column, defense representative argument. And fourth column, Lordship, which is important, enquiry officer opinion. Very cryptic and without explaining cleansing the evidences or material before him, he has just formed an opinion that after going through the image produced by the PO and after hearing the argument made by DO, it is established that the DO has deliberately committed the irregularity and hence charge is proved. Had there was a Lordship proper explanation against this charge sheet, I could have Lordship, I could have challenged this enquiry report on that ground only. Because that enquiry officer's opinion, based on no evidence, and it is not a speaking order like Lordship.
Is the inquiry report dated?
Lordship. And this is enquiry report.
Is it dated? Is there a date?
That Lordship, that page 18, this enquiry report was forwarded to me.
Date. Any date?
So, no, that is mentioned, Lordship. What is that? What the 21 to 30 সেইখন। There is no date, Lordship, but they must forwarded to me by letter dated 12/6/10.
Where do you get?
By the page 18, Lordship.
18.
18, 18, Lordship.
Yes, your written statement has
No, Lordship.
finished everything.
Head Gavier
Second-
return statement, Lordship.
Second show cause notice is not in accordance with law.
Law, Lord.
You could have interfered. Come to the second show cause notice, page 18.
Page 18, Lordship. Yes, there is also no any reply against that.
No, you read the content.
That
You know
above,
how to,
above such issued on you under regulation so and so. Enquiries conducted and all reasonable opportunities were provided to you at the enquiry. The brief of the presenting officer was provided to you so and so, and you also submitted your written agreement. The enquiry officer has since submitted a report by dated Lordship 9/4/10, Lordship. And I concur with the finding of the enquiry officer report. The report of the enquiry officer is enclosed for your perusal. You may tender your written submission on the finding of the enquiry officer within 15 days from the date of letter. If nothing is so and so.
this second show cause is not sustainable. Why?
The proposed penalty is
Not required. Why is it not sustainable? What is the meaning of a second show cause?
Lordship, it is not second so Lordship. It is the just submission of enquiry report.
This is a second show cause notice. You may tender your written submission, your findings. This is a second show cause notice.
Lordship, second. The second sub suppose in my humble understanding will be come from the disciplinary authority, not from the enquiry officer.
Who is given this? Page 18 is the disciplinary authority.
Disciplinary authority, Lordship.
What is the lacuna in this second show cause notice? There is a major lacuna. You have not even been able to point out. What is the purpose of a second show cause notice in a DP?
That delinquent is informed that what is the finding and what penalty is
Penalty is not required. Delinquent is informed what?
about the
What is the purpose? The doctor, you should do some research. These are minimum facts. What is the objective of a second show cause notice? It is to give you a reasonable opportunity to make your submission before the disciplinary authority, not to concur with the findings which are against you.
Lordship,
Now, the disciplinary authority, while forwarding the inquiry report, has already concurred.
Lordship.
Is there any scope of a reasonable opportunity? This has become an anti-formality, but your written statement is creating the problem. This we will have straight away interfered. See, here I have concurred with the finding. If you already have made up his mind, then where is the scope of you to make him convince him to take another view? The disciplinary authority is only to forward the report. This is the report against you. If you haven't got anything to say, then I'll make up mind. He has already made up his mind.
One step ahead.
That this is the meaningless inquiry taken to court note. But your written statement is against.
Yes, sir.
What is the penalty? Let us see the penalty. Did
Compulsory.
you file any this thing?
No, Lordship.
Representation against the inquiry report? No.
No, Lordship.
No representation filed.
No, Lordship.
Yes. Next, where is the inquiry? Where is the penalty order?
Lordship, 25.
Concur. See, this concurrence is at the final stage. This is okay. But this concurrence has to be there after considering your representation against the inquiry report, which you have not done. The major penalty, you are what? Impose the major penalty, compulsory retirement.
Compulsory retirement.
Did you get anything?
Gratuity and some
You
other
got.
things.
Yes, Mr. Doctor.
Lord, everything is established, as the Lord question.
PPP Doctor. That accounts for the petition who by means of this petition, please have your seat. By means of this petition has put to challenge a departmental inquiry initiated by a charge memo dated 21/2/2009. The petitioner doesn't have put- doesn't have- not okay. Her typical learn from substance, whereas the respondent bank is represented by the account assisted by yes, what's the name? Name K. Upamanyu. The subject matter of dispute in the state petition is a departmental process which has culminated in an order of imposition of penalty of compulsory retirement. Did you file any appeal?
Yes, appeal was rejected, Lord.
The departmental appeal referred by petition was also rejected. Before going to the issue which has arisen for adjudication, the fact may be narrated as that the petition has joined the services of the erstwhile Pragjyotish Gaundia Bank in the year 1990 as an officer. The state bank was subsequently amalgamated with 3 other rural banks and emerged as the Assam Gramin Vikas Bank. While in service, on 21/2/2009, a charge memo was served to the petition containing 5 numbers of charges, including the charge of illegal withdrawal of customers' money. The petitioner, however, in his written statement of defense dated 8/5/2009, did not deny the allegation and had rather undertaken to make good the loss. The matter was proceeded and an inquiry was instituted. The inquiry officer had submitted a report which was forwarded to the petition on 12/6/2010. The inquiry report states that charges against the petition were proved. The petitioner, however, did not make any representation against the inquiry officer, against the inquiry report. Consequent by the impugned order dated 2010, comma, the petitioner was imposed the penalty of compulsory return, which is a major penalty under regulation. Correct? The PP Senate Council for the petition has submitted that the working condition at that particular point of time was such that he was compelled to do certain activities. It further submitted that the penalty is harsh and not commensurate to the gravity of the offense, and therefore interference be made. It is further submitted that while disposing of departmental appeals, the appellate authority did not apply independent mind and had mechanically rejected the appeal. Per contra, the Senior Council representing the bank has submitted that the scope of difference represented is almost is minimal, as almost is minimal, as in the present case, there was no denial at all from the delinquent petition. By referring to written statement dated 8/5/2009, written statement of the file submitted by the petition against the charge member, it submitted that instead of denying the allegation, the same were admitted with an undertaking to make good the loss. The Senior Council submitted that under such circumstances, the inquiry itself was not warranted, and the matter would have been brought to a logical end. However, to give a fair opportunity, an inquiry was conducted in which, the inquiry officer had examined witnesses and also took into consideration fair number of exhibits proved by the management. The inquiry was held on 4 sittings, and thereafter the findings were made whereby the charges were held to be proved. It is further submitted that the petitioner chose not to submit its representation against the inquiry report in response to the second show cause notice dated 12/6/2010, and therefore, it can be deemed that the petition was satisfied with both the procedure and the findings of the inquiry officer. The Senior Council according to that the penalty imposed has been done by following due procedure in law and taking into account the seriousness of the charges which includes illegal withdrawal of customers' money, the penalty is not at all disproportionate. After hearing the parties and on examination of the material on record, this court is of the view that in exercise of the powers conferred under Article 220 of the Constitution of India, this court role of judicial review in matters of disciplinary procedure is circumscribed, and only when a case is made out of patent illegality or gross perversity, this court would be loath to interfere with such a disciplinary procedure. This court may, however, interfere even in a case where the punishment imposed is excess disproportionate, as was later in the Denmark case of Sweden. However, in the instant case, apart from the charges being serious in nature, there was no denial at all from station at any stage. First, in the written statement of defense dated 8/5/2009, wherein the first opportunity was given, rather than denying, the petitioner had accepted that and had undertaken to make good the law. A bank employee holds the duties discharged by a bank employee is mainly on fiduciary capacity, wherein the doctrine of public trust is applicable. Ultimately, is the public money which is involved in any such disciplinary procedure involving allegation of defalcation and misappropriation. That apart from the inquiry report and the inquiry report furnished by the inquiry officer also does not disclose that there has been any gross violation of the procedure or the principles of natural justice in conducting the inquiry. And what intrigues this court is that the petitioner chose not to even submit a representation against the report of the inquiry. This court has also noticed that the order of penalty is of compulsory retirement, and this court has been surprised that under such penalty, the petitioner had received his. What did you get, Mr. Doctor? After the compulsory retirement, what?
Lordship, just now I have taken instruction that some benefit is yet to receive, Lordship.
That the petitioner received such benefit that under the process court is of the that the present is not a fit case. or interference. There is however maintained that whatever entitlement is to be received by the after imposition of penalty of compulsion from the same be released to him if not done in the meantime.
Obliged, Lordship. Matlab.
May I please, Your Lord. Lordship, issue involved with this case is negated by this honorable court, Lordship, in writ appeal, Lordship. However, Lordship, the writ appeal is pending before the honorable Supreme Court, Lord.
SLP is pending.
SLB is pending, Lord. In similar issue, Lord.
But the
Issue for regularization or one-day regularization by creating a supernumerary post for the purpose of pensionary benefit to the master of labor, Lordship. It was rejected by the divisional bench, Lordship, in open das case, Lordship, writ appeal 45. And few cases are
when
pending,
does the subject matter of appeal in the Supreme Court
Lordship,
pending?
pending, Lordship. One of them
When does
is
this 45 of 2011 or
2015, Lordship,
45?
45. It is 14, Lordship, reported in
45, 2014.
14.
14.
But to have this pending,
Lordship, I think, Lordship, per my information, Lordship, it was listed for hearing, Lordship. SLP is listed for hearing in the last week, Lordship.
Madam,
First of all, it's the MR worker.
no, no, on fact,
Yes, yes.
of the procedure set up. Here, the
Yes, yes. I have
When
no
does the-
objection. I have no
2012 matter.
12 matter, yes.
The eight Talukdar that counsel the petition. Both the eight Talukdar and counsel and MSS certain topic of work as sub that the issue involved was sub before the writ appellate court, which in the case of Pendas, state of Assam versus Pendas, which was a writ appellate number 5, and honorable had declined the relief. The Senate however, has informed the court that an asset has filed in state and is been put according to that the matter may be deferred to enable deferred deferred to be listed after a decision is rendered by the Honorable Supreme Court. Considering the aforesaid submission as well as the fact that this petition is pending since the year 2012, that this matter be called again after a month, by which time, the Senate counsel for the party may obtain the up-to-date record.
Obliged, Lord.
On last occasion of the National Council of Teachers Education has took time to file affidavit, they have filed affidavit.
Item number 7,
Yes.
Lordship, item 11, I have filed an application for vacating stay, and Lordship want to heard the matter and finally dispose the matter, considering the fact that they have challenged the BA degree of the petitioner on the ground that petitioner has BA degree in 1997 from Shashi Bhushan Institute of Education from Silchar. And that
One
was
matter we have heard of what?
Lordship. Lordship has heard the matter.
One matter.
matter was heard.
No, have we heard one matter for CFD?
Lordship. Not this matter was heard.
This matter was
This matter was heard.
Lordship.
When?
It was heard on Lordship 2/6, and before that also Lordship has heard the matter.
We remember Shashi Bhushan.
Lordship. In this particular case, my submission of Lordship is remember that already single bench of this honorable court has decided that BA degree of the petitioner is valid, and thereafter they have preferred appeal. Appeal also dismissed.
One.
11.
should be in item number 11.
You have to repeat. We don't have any more. We'll take a for final discussion.
My dear Mr. Kapil Chaudhary is talking. I'll be led by Mr. Kapil Chaudhary, Senior Counsel Malad.
Oh, no, doesn't matter.
Is
We'll
coming.
start.
Malad.
But we'll start from the scratch.
Lordship. May I hand over Lordship the list of dates?
How many petitions are there?
Lordship, I am one.
No, there are how many petitions?
Three matters, but the
Whether
Pre-read petition.
petition, but petitioner is number one, only one.
Malad, whether the Lordship is taking up the IA or the
Entire.
and that
Yes, all matters.
I'm
The
the
old matters,
petitioner,
aren't they?
I'm the petitioner, Malad.
Yes.
When I filed the certificate petition, Malad.
Lordship, earlier occasion Lordship said I will dispose the matter finally.
Here the entire matter.
Then Malad, the petition will be hard fast. Malad.
You're the petition.
Yes, Malad.
We'll hear. Again,
Here to see, sales my property.
you come this side. We can't hear. Come this side.
Item number 10, Lordship, I representing the respondent number 4. My learned friend, he representing the petitioner. Lordship. Here he Lordship excel my promotion order. Lordship. So this matter is Lordship completely different to the item number 11. So this matter will be taken up today itself, but taken it separately.
We can take it up separate.
Lord,
Any issue,
item
no,
10.
no problem.
Yeah. The pleadings are also complete.
Mr. Gustami, what is your item number?
11.
Then we take up 10 first or 11 first.
My lord, there are three sets of case in bank, my lord, in respect of three colleges. So, my lord, one is Shashi Bhushan, one is, my lord, Vivekananda College, and one is Bahatar PH College, my lord. So, issue is basically same, but the factual aspects are different.
Baihata and the Shashi Bhushan are connected.
Not connected, but so far the item number 10 is concerned.
10 you are in
Here,
Baihata.
Lordship, I am Lordship of the, my primary dispute is that regarding the maintainability of the repetition.
No, those will come
But
one
so
after
far
the
the-
other. Let us take up serially then,
Serially,
which is the first matter.
Item,
item 7, my
We'll hear all the cases separately.
yes, yes. Item 1.
Also 7, the issue would be same for Dr. Sosibitan in 7, 8 and 12.
Let us start with the 7.
Same
Wherever
item
the
number
common factor is there, with
Lord, Lord.
7 was the petition.
I am the petitioner.
Okay. And Mr. Decker,
I'm item number 10, Lord.
seven,
7.
7 8 and 12 I feel.
7 you are
The
there.
issue is same with regard to Dr.
Okay, that's fine.
Very much near
Doesn't- Forecast for the petitioner in
Yes,
item number,
7, my lord.
and what is the petition number?
In 429117, my lord.
Four two nine one.
Yes, sir. 17.
Name Vijayanath
Vision.
by people cast.
Yes.
Or and who Mr. Das for?
Private respondent.
Private respondent number
Cluster for
for respondent number 9, Lord.
NCT. NH cluster. Sorry, NH Borvia for NCT and Madam? No, but who is the main contesting respondent? Education. Education. Terang P4. For Kendrick. Ardeka for
Lordship is item number 7, 8, and 12, and 11 is same lordship pertaining to B.Ed degree obtained in the year 1997 from Dr. Srishti Bhushan Institute. Lordship, if item number 11 is argued first, lordship, my senior is appearing, and
His senior is there, my lord.
that is well.
Well, because 7 will cover the item 11 will cover the 7 also.
Also covered 7, 8, and 12.
Yes,
Issue is same.
first you sort out. Which will be first?
I have no
We'll
problem.
give
my
you
lord.
one hour.
I have no problem. The senior is there, my lord.
That is
After
well.
starting the hearing, then again you will be changing places.
No, no.
Tell us which will be convenient for all the parties.
Because
Which
in
one?
11 lordship, my learned senior friend has already placed some.
Factual aspect.
No, we don't remember anything. We'll start from a scratch. Whatever you say.
Yes, sir. Sure.
Mr. Chaudhary. No, you tell us. Convenient for all the parties, which case will be start first. We know that there will be some issues which will be common, but
Lordship, 11 may kindly be taken up first.
11.
Item
11
number
who is the
7.
petition?
I am
Name. What is the number?
Mustafir.
Number.
WPC 5221
5221.
of 22.
Five double two one 22. Uttar Pradesh. With you, who is there with you? Sakya is there.
Yes, thank you.
And who else? And the respondent?
I am for the response.
Terang for secondary. Ardeka. Assam University.
Assam University is not a party here.
Not a party.
In this case, at least. In my case.
And who else? For NH. NCT. And Mr. Goswami for
7 look.
R7. Name.
Mofruddin.
R7. Name.
Mofruddin.
MO.
FUR. UEEIN.
Okay. Yes, please.
My lord, the subject matter of challenge in this writ petition is a communication at page 73. My lord, that order has been passed by the government in the secondary education department, pursuant to an order passed by this honorable court remanding the matter. My lord, may I read the order of the this court?
Can you plus send the fact that will be
The issue here is, my lord, whether a particular degree of that particular my lord college, which has been obtained by the respondent number 7, is valid or not.
degree of BA?
BAT.
R7 is Mr. Gustam.
Yes.
Who are you?
I am, my lord, now holding the post of principal of a Mala Higher Secondary School, Balester Higher Secondary School.
Petitioner, principal.
I was appointed, my lord. There was a dispute earlier. I was appointed because of the fact that, my lord, the private respondent's degree has been held to be invalid by the, my lord, by the government. And thereafter, I was appointed as principal. Then the writ petition was filed, and then in the writ petition,
Earlier, his degree was interfered with the government.
yes, my lord, by the government.
Same BA degree.
Same.
BA of R7 invalid.
Then, my lord, the private respondent filed the writ petition. And in the writ petition, this honorable court remanded the matter back to the authorities.
What was the writ petition?
Writ petition number 3551 of 2021. 3551 of 2021, filed by Mafuruddin, the respondent number 7 herein. And this honorable court, my lord, remanded the matter back to the authority. That order was passed on 9/8/2021.
8/20.
Pursuant to that direction, my lord, the order impugned in this writ petition has been passed, holding his degree to be valid. Therefore, my lord, I am before your lordship.
The matter was remanded for whom? Director of Secondary Education.
It was remanded to the, my lord, government in the secondary education department.
Okay, where is the impute order?
Impute order is at page 73.
By which his degree has been held to be valid.
Held to be valid. And it was ordered that he may be appointed as the regular principal of the school.
Just 71 is 17/8. 17/8 to 2021. 17/8/2021. The order date.
Order is 2nd June 2022. 2nd of June 2022.
You said page 71.
73.
What is 71?
Page 71, my lord.
71 is not relevant.
Not relevant.
73.
Yes.
2nd June.
2nd of June 2022.
Yes.
I'd like to, subject to your lordship permission, my lord, I'd like to read the order of the honorable court first, because, my lord, I'll show that the direction has not been complied with in its true spirit.
This is by the government.
Yes, my lord.
To 2nd June by Secondary Education Department.
Additional Secretary to the Government of Assam. Yes, Secondary Education Department.
Just we'll go to that order.
Page 66, my lord, is the order of this honorable court.
Page 66.
Page 66, my lord, the order starts. I'll write, my lord, no, I'll not read the entire story, my lord.
Or you are referring to 9/8/2021 order.
Yes, my.
Yes.
Paragraph 2, both the petitioner as well as the respondent number 6 participated in the selection process for a regular appointment to the post of principal, Balester Higher Secondary School in the Kachar district. Then, my lord, paragraph 3, I'll read, my lord. It is an admitted position that the selection will be governed by the provisions of the Assam Secondary Education Provincialized Service Rules 2003 and not by the Assam Secondary Education Service Rules 2018. In advance, as the process for selection was initiated prior to the enactment of the rules of 2028. My lord. 18. The procedure for appointment under the rule 2003 is provided under rule 3 thereof. Then, my lord, the procedure has been, my lord, stated in paragraph 4. Paragraph 5, I'll read, my lord. In the evaluation of the school selection committee, the petitioner Mofaruddin, who is the respondent number 7 here, my lord, was placed as serial number 1, whereas the respondent number 6, Machabbir Ali, the petitioner, my client, was placed second, and the B.Ed degrees of both the petitioner and the respondent number 6 were taken into consideration. When the matter was pending before the state selection board, the respondent number 6, Muchabbir Ali, submitted a representation raising an allegation that the B.Ed degree of the read petitioner Mofaruddin was obtained from an institute, namely Dr. Shashi Bhushan Institute of Education, and as the said institution has received its recognition from NCT on 31/2000, the B.Ed degree is liable to be not recognized. So this was my case. The State Selection Board, by an order dated 10/9/2019, overruled such objection of the respondent number 6 by arriving at its conclusion that the NCT had extended the last date of receiving the applications for recognition up to 18/8/1997, and the institute concerned, namely Dr. Shashi Bhushan Institute of Education, has submitted its application prior to the same date. Accordingly, the conclusion arrived was that the B.Ed degree of the petitioner was a valid degree under the law. The State Selection Board also recommended the petitioner Mofaruddin to be the first candidate in order of merit in the select list. As required under Rule 13 sub 5, when the matter went before the government for its approval, the order dated 29/7/2021 was passed under the signature of the Additional Secretary to the Government of Assam in the Secondary Education Department. In the said order of 29/7/2021, the government arrived at its conclusion that Dr. Shashi Bhushan Institute of Education, which was earlier named as Hailakandi B.Ed College, which is a private college, did not apply before the NCT for recognition within a period of 6 months from the appointed date. This will be relevant, my lord, for determining the issue in the writ petition. Date of enforcement of the NCT Act. The only reason given is that the application for recognition was not made within 6 months of the appointed date of the NCT Act and coming into its force, and therefore the B.Ed degree obtained by the petitioner from Dr. Shashi Bhushan Institute of Education was an invalid degree. Based upon such conclusion, the respondent number 6, Muchabbir Ali, the petitioner now, was appointed as regular principal of the college concerned, which is school, my lord. Being aggrieved, the writ petition is instituted. Mr. A.R. Bhuyan, learned counsel for the petitioner, raises a contention that the institute, Dr. Shashi Bhushan Institute of Education, had submitted its application for recognition before the NCT on 12/8/1997, whereas as held by this court in Pranita Sharma versus State of Assam and other WPC so-and-so, the last date for submission of such application was 18/8/1997. As the application was submitted within the acceptable time limit, therefore the B.Ed degree obtained from such institute is valid degree. Mr. R. Majumdar, learned counsel for the Secondary Education Department, Government of Assam, agrees that in the judgment of this court in Pranita Sharma, it has been held that any application by an institute offering B.Ed degree, if made prior to 18/8/1997, the B.Ed degree obtained through such institute would be a valid degree. From the said point of view, the conclusion arrived in the order of Additional Secretary to the Government of Assam in the Secondary Education Department dated 29/7/2021 regarding the invalidity of the B.Ed degree of the petitioner is on the basis of an incorrect proposition of law. Mr. I.S. Shaikh, the learned counsel for the Resolution number 6, on the other hand, submits that the NCT Act came into force on 1/7/1995, and the appointed date is 17/8/1995, and the date of submission of application for recognition was extended up to 18/8/1997 only in respect of such institute which were in existence on the date when the Act came into force. The subsequent date of 18/8/1997 would not be applicable in respect of such institute which came into existence after the appointed date of NCT Act.
Welcome.
Mr. Saike raises an allegation that Dr. Shashibhushan Institute of Education was not in existence as on 7/8/1995 when the NCT came into force in as much as it was established on 31/12/1995. We find that the said submission of Mr. I.S. Saike requires a consideration. Then your lordship may skip my lord paragraph 14. Paragraph 15 is the my lord the direction.
Yes.
For both the aspects, the matter stands remanded back to the Additional Secretary of the Government of Assam in the Secondary Education Department for his determination. Firstly, whether the Dr. Shashibhushan Institute of Education has made its application prior to 18/8/1997, and secondly, whether the said institute was in existence as on 17/8/1995 when the NCT Act came into force, and accordingly pass a reasoned order thereon. Then, my lord, your lordship may kindly come to the impugned order at page 73.
Yes.
This is, in fact, my lord, a communication from the government to the director, pursuant to the this honorable court's order. With reference to the subject cited above, I am directed to inform you that the Honorable Guwahati High Court, in its order dated 9/8/2021 in WPC 3551 of 21, the matter regarding appointment to the post of regular principal of Balester HS School was remanded back for a fresh consideration by taking into account that in the Pranita Sharma judgment WPC 3289, the last date for submission of application to NCT had been held to be 18/8/1997, and any institute which makes its application prior to the said date, the BA degree obtained from such institute would be a valid degree, but at the same time, determination would also be required whether the institute which has submitted its application prior to 18/8/1997 was in existence as on 17/8/1995 when the NCT came into force. Accordingly, a report was called from the regional director NCT so-and-so address on 39/2021, and the subsequent regional director Eastern region has submitted a report on 16/11/2021, copy enclosed, wherein ERC NCT has informed that an application for grant of recognition for B.Ed course dated 12/8/1997 was submitted by the institution, namely Dr. Shashibhushan Institute of Education, Hailakandi B.Ed College, dated 21/8/1997. The matter was also referred to Judicial Department for their legal views, and the LRCOM Commissioner and Secretary in charge Judicial Department submitted their legal views on 13/4/2022. In the instant case, the institute, namely Dr. Shashibhushan Institute, RP Road, Hailakandi, has applied to NCT on 12/8/1997, and therefore the B.Ed degree of Sri Mofizuddin, who was a student during the session 97/98, it should be 98, and passed out in 96/97, passed in 1997, is valid from the legal point of view. Accordingly, Mofizuddin, the subject teacher, may be appointed as a regular principal of the school. Now, your lordship will notice, my lord, they have referred to one, my lord, communication from the NCT, where the application that has been submitted, the date has been given, and the issue regarding the existence or otherwise, that issue has not been, my lord, considered in this order. Now, I'd like to take your lordship to the, my lord, provisions of law.
Just,
The NC, my lord, I have
just
my learned friend has given a list of dates, my lord, that your lordship may refer to. 4 dates are very important, 4 or 5 weeks. And my lord, I have given a compilation of the act and the, my lord, the citation style bill act. 4 dates your lordship may kindly, my lord, take note of. The NCT Act came into force on 1/7/1995. And 17/8/1995 is the appointed date. 1st of July, my lord, the act came into force. Appointed date is 17th of August 1995.
what is the difference between if the NCT came into force on 1/7/1995?
Because, my lord, the appointed date has been, that word have been, my lord, referred to in the act itself. I'll come to that, my lord, the relevance of that. Then your lordship will kindly note on 31/12/1995, the SB Institute was established.
31?
31/12/1995, 31st of December 1995
Shashi Bhushan was
is established. Then before that, after that, my lord, 12/8/1997, the college applied for recognition.
Yes.
And the recognition came on 13/1/2000. Recognized. And another date is important, my lord. In the list of dates my learned friend is given, that is given last. The respondent number 7, he, my lord, appeared in examination in June 1997.
7 means
For that, my lord, I'll take your lordship to page 21.
Mafuruddin.
Mafuruddin, my lord.
He
He
applied.
appeared in the examination, BEd examination in June 1997. I'll substantiate that with the document, my lord, at page 28 of the WPC.
Or 7 appeared for
Appeared for the BEd examination. So, my lord, these are the relevant dates. Now, my lord, I'd like to take your lordship to the, my lord, NCT Act certain provisions. That is in the compilation.
no, are we required to put the provisions?
Yes, my lord,
Because the remand order is not the subject matter of any challenge. It has asked the government to do a particular exercise
in a particular manner, it has not been done, my lord.
Now, 2 issues were called out in the order by which the remand was made. If you come to the order,
yes,
at page 69, paragraph 15,
yes,
you have just read. Paragraph 15.
my lord.
First is whether SB Institute had made its application prior to 18/8/1997.
Yes.
And secondly, whether the institute was in existence on 17/8/1995 when NCT Act
Yes.
came into.
Yes.
These are the two.
These are the two issues. Now, my lord, what is the effect of existence and non-existence of the particular, my lord, college? That, my lord, I want to show from the, my lord, the.
No, are you contending that when the NCT came into being, this college was not
It was not existing. And my lord, the extension that was granted was for my lord existing institute.
So this is a factual dispute. What does the government say?
No, there is no dispute, my lord. I'll refer to the affidavit of the NCT, my lord. It has given the dates. It has given the date.
NCT also says that it was not existing.
It was not, my lord. It doesn't say specifically, but the dates have been given, my lord. From the date, paragraph 3 of my lord, their affidavit, it can be called out that it was not in existence. If it is not in existence, what is the effect? That is the my lord, whole issue to be determined. Because my lord, earlier the matter was,
Who is for the college distribution?
my lord,
Anyone for the college?
no, in fact, my lord, we have not made the college a party, my lord. But the dates are not in dispute.
But Department, Education Department. Madam Director,
I refer to only, my lord, two provisions of the Act.
Yes. 1923 Act.
1993 Act, my lord. Section 14 at page 8. What I am trying to, my lord, urge your
Section 14. 1/4.
one.
Section- Yes.
Recognition of institutions offering course of training in teacher education. Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may, for grant of recognition under this Act, make an application to the regional committee conformant in such manner as may be determined by regulation. So, my lord, this requires that every institution, my lord, after the appointed day, established after the appointed day, may apply for recognition. But there is a proviso.
Yes.
Provided that an institution offering a course or training in teacher education immediately before the appointed day, that is 17/8/1995, shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period and until the disposal of the application by the regional committee. So, my lord, there are two classes of colleges. One existing, proviso is for the existing, and the one which came after the, my lord, the appointed day. So this college of the respondent number 7 falls under the first category. It was not in existence. So for this proviso is for those colleges which are in existence. Then may I take your lordship to section 16 and 17. 17(4) to be exact. Section 16, affiliating body to grant affiliation after recognition or permission by the council. Notwithstanding anything contained in any other law for the time being in force, no examining body shall on or after the appointed day grant affiliation, whether provisional or otherwise, to any institution or whole examination, whether provisional or otherwise, for a course or training conducted by a recognized institution, unless the institution concerned has obtained recognition from the regional committee concerned under section 14 or permission for a course or training under section 15. So, my lord, for affiliation and for conducting the examination, this requirement of section 14 has to be fulfilled. Then section 17, contravention of provisions of the Act and consequence thereof, I take your lordship to section 17(4).
if an institution offers any course or training in teacher education after the coming into force of the order withdrawing recognition under subsection 1, or where an institution offering a course or training in teacher education immediately before the appointed day fails or neglects to obtain recognition or permission under this act, the qualification in teacher education obtained pursuant to such course or training or after undertaking a course or training in such institution shall not be treated as a valid qualification for the purpose of employment under the central government and any state government or university or in any school, college or other educational body aided by the central government or the state government. Then, my lord, one amendment came, that is also, my lord, that will be also relevant, that your lordship will find at page 17 of the compilation. Okay, 17. Page 17, section 2 of this Amendment Act. In the National Council for Teachers Education Act 1993, in section 14, in subsection 1, after the proviso, the following proviso shall be inserted, namely, provided further that such institutions as may be specified by the central government by notification in the official gazette, which are funded by the central government or state government or the Union Territory Administration, have offered a course of training in teacher education on or after the appointed day till the academic year 2017-18 and fulfill the conditions specified under clause A of subsection 3 shall be deemed to have been recognized by the regional committee. My lord, I am drawing your lordship attention to this provision to show that the government institutions have been given a, my lord, special treatment, not for the private sector. Now, my lord, the case that has been sought to be, my lord, made out is that there was an extension which was granted by the NCTE for filing an application. If your lordship comes to page 48 of the writ petition, this is my lord, communication from the NCTE. I'll read the paragraph 2 at page 48. It is a communication to the Assam University. In accordance with the provisions contained in section 16 of the NCTE Act, after 17 August 1995, no examining body can grant affiliation, provisional or otherwise, to any institution or whole examination, whether provisional or otherwise, for a course or training conducted by an institute unless the institute concerned has obtained recognition, permission from the regional committee concerned under provisions of section 14 and 15 of the Act. Further, in accordance with the provisions contained in section 17 of the Act, qualification in teacher education obtained pursuant to a course or training from institutions which fall or neglected to which fail or neglect to obtain recognition permission under the Act shall not be treated as a valid qualification for the purpose of employment under the central government, any state government or university, or in any school, college, or other educational body aided by the central government or state government. It will thus be seen that while the universities cannot grant affiliation to a college offering B.Ed, etc. courses and cannot hold examination for a course of training offered by an institution unless the institution concerned has secured recognition from the NCTE, the student pursuing courses from such unrecognized institution will suffer serious adverse consequences in the matter of securing employment. In view of the position explained above, there is an urgent necessity for all colleges and university department of education offering B.Ed and other teacher training courses to apply to the concerned regional committee of the NCTA for recognition, it is requested that you may please issue necessary instructions to all the colleges affiliated to your university and offering teacher training courses as well as to your departments of education to immediately apply the recognition well before the last date, 18 August 1997. So, my lords, by this, the provision of the statute providing 6 months, that has been extended. Now, one question arises whether by a communication, a provision in the statute can be modified without amending the act. Since we are not challenging this, my lord, notification, we will not go into that. But my lord, statute provides for 6 months. It has, my lord, extended. In any case, my lord, let us accept this, my lord, extension up to 18 August 1997. So, my lord, the case of the private respondent is that it has applied on 12/8/1997, that is prior to this date, 18 August 1997. Now the question therefore comes. This extension is for the institutes which were in existence on the appointed date. And this extension has been rightly or wrongly given. We need not go to the validity of this extension, but the extension is there, but limited to the institutes which were in existence prior to the appointed date. So far as the institute from which the respondent number 7 obtained the degree, it was not in existence on the appointed date. Therefore, this extension cannot save them from the limitation of the requirement of recognition. In fact, my lord, there is no limitation prescribed as such. They have to apply for recognition, then only they have to start the course. So that is precisely the case of the petition. Now, what happened, my lord? There is one division bench decision. It will be necessary for me to, my lord, place before your lordship.
Pranita.
My lord.
Pranita.
No, there is another decision. Page 41 of the read petition. Different page. Pranita has not gone to division bench. The small judgment. Page 43, my lord, is start. I'll read it from the last paragraph in this piece, 43. Page 43, my lord. Third paragraph of this piece. The private respondent herein had contended that the appellant herein, who was appointed to the post of principal, was not passing eligibility qualification as the B.Ed degree obtained by the appellant herein from Silchar College of Education was not recognized by the NCTA. The learned single judge, while taking note of the said contention and justification sought to be put forth by the appellant herein, was of the opinion that B.Ed degree obtained by the appellant herein was not recognized, and in that light, having taken into consideration the advertisement dated 16/6/2016, was clear that only recognized B.Ed degree would be acceptable, has arrived at the conclusion that the appointment of the appellant is contrary to the requirement, and has accordingly, by the impugned judgment, set aside the appointment and directed reconsideration of the matter as indicated therein by the authorities. The appellant, therefore, claiming to be aggrieved, is before this court. Insofar as the factual aspect, the date as taken note by the learned single judge would be relevant in that regard, it is notified that the advertisement is dated 16/6/2016. The advertisement indicated that B.Ed degree obtained from the off-campus like CJM, Bharati Shiksha Parishad, Nava-Bharat Shiksha Parishad, or any other institute not having NCTA recognition cannot be accepted. Then, my lord, the ratio is laid down in the next paragraph. In that background, the admitted facts that are that the B.Ed degree obtained by the appellant herein was in the year 1998, and the Silchar College of Education, from which the appellant had obtained B.Ed degree, was recognized by the NCT only on 11/8/2003. It is also the undisputed position that NCT Act 1993 came into effect on 1/7/1995. In that circumstances, since the degree obtained by the appellant was subsequent thereto, on 1998, without recognition from the NCT, such degree was held to be invalid. To that extent, the appellant in any event is not in a position to lay any other material before this court to controvert the said position. The learned senior counsel for the appellant has, however, sought to rely on the National Council of Teachers Education Ordinance 2006 to contend that, as per 16(8), thereto the defaulting institute had been provided an opportunity to file application and seek a recognition of the course, and in that circumstances, the institutions which have applied have been granted recognition with effect from the inception of the institutes. Though such contention is sought to be put forth, the same would not be of any assistance to the appellant herein, since admittedly the recognition to the institute from which the appellant secured B.Ed degree course was granted only on 11/8/2003 for the academic year 2003-4. In such circumstances, when the institute itself has not made any application under the ordinance, not the act, ordinance to which reference is made, and no benefit thereunder has been sought, it would not be proper for this court to provide any other benefit to it which has not been provided under the ordinance. Even otherwise, the benefit at this juncture cannot be extended in a circumstance when, as on the date of advertisement, the B.Ed degree obtained by the appellant was not recognized in accordance with law. So here also, my lord, the recognition came much after the petitioner, the respondent number 7 appeared in the examination in June 1997, and the application for recognition was made on 12/8/1997. Before that, my lord, she has appeared in the examination, and the recognition came only in 2000, 13th of January 2000. Now, NCT has filed an affidavit. So one of the division bench I had referred to show that, my lord, the date of recognition is the relevant date. And that has also, my lord, not very clearly stated about the, that issue has not been, my lord, determined as to what will happen to the institutes which were not in existence on the appointed date. So that has not been, my lord, finalized, settled in law. But there is another writ appeal on that issue which is pending, but no order has been filed. I'll show an affidavit there, my lord, the NCT has filed. I'll show, my lord, the NCT. In fact, my lord, I'll show, my lord, 3 affidavits of the NCT where their stand, my lord, differs from case. First, my lord, you also will take up the affidavit filed by the NCT in our case. Then I'll show, my lord, in another case what they say, and also in, my lord, in the read appeal what they have said. Now, in your lordship will find in their affidavit in opposition in the present case, dates have been, my lord, clearly stated, because the dates are not in dispute. But what will be the effect, that is what is to be determined. May I take your lordship to paragraph 7 at page 6 of the, has your lordship got the affidavit? Paragraph 7 at page 6, that as regards the amendments made on the paragraph 3 of the IS so and so, why paragraph 7. Oh, I'm sorry, Miller, I'm sorry. I've taken a different affidavit. I'm sorry. No, Mark, affidavit filed on 11th of August. Paragraph 3.
That the respondent number 7.
Yes, madam. that the respondent number 7 obtained his B.Ed degree from Dr. Shashi Bhushan Institute of Education, Hailakandi, earlier Hailakandi B.Ed College, in the year 1997. I pause here for a while, my lord, without my lord really saying, pointing out that the examination was held in June, my lord, 1997. And admittedly, then the Hailakandi B.Ed College submitted their application on 12/8/1997 for recognition before the NCT. Moreover, the said college subsequently, on the basis of the said application, by order dated 13/1/2000, get provisional recognition from the NCT, and thereafter recognition was granted. So one very vital aspect has been, my lord, not disclosed in this paragraph. My lord, I'll refer to a document to show, my lord, that the importance of that date. But in, my lord, paragraph 11, it is said that the NCT allowed the B.Ed degree from that institution, but the date of effect has also not been stated. This is a very evasive affidavit. Paragraph 11, may I read? That the deponent begs to state that Assam University, while later it is so accorded permission to start the then Hailakandi B.Ed College for the session 96-97, and while later, dated 28/1996, the Assam University informed the NCT that there were 5 B.Ed colleges within the jurisdiction of the Assam University, which includes the Hailakandi B.Ed College, which had been offering the B.Ed degree, and assured the NCT that henceforth permission will not be granted for opening any B.Ed college without prior approval of the NCT as required under the NCT Act. The NCT Act came into force with effect from 1/7/1995. Under Section 14 of the NCT Act, the institution offering a course of training in teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months, which was extended up to 18/8/1997. The deponent humbly begs to state that NCT allowed the B.Ed degree obtained from the institutions who have applied within 18/8/1997 as valid degree. Many things have not been disclosed, my lord. So it is a, my lord, false statement that any institution which has applied within the extended date of 18/8/97, those degrees are valid. That is what I understand. Without taking into consideration the fact when the, my lord, institution came into being. And the Section 14 of the Act has been referred
No,
to.
in the earlier paragraph, the year has been stated. Paragraph 3.
My lord, what is the effect of that?
Because
Because 13
R7 obtained his B.Ed from Dr. Surensu in the year 1997. Admittedly, the then Hailakandi B.Ed College submitted their application in 12/8/97 for approval.
Yes. Yes, that has been stated, but that the before the application was filed, the respondent number 7 completed her course and admitted and my lord appeared in the examination. For that, my lord, may I take your lordship to page?
Now, assuming what you are saying correct position.
Is correct, my lord. From that.
That before the application was filed, he had already got a B.Ed degree from an institute which was yet to be recognized.
Yes.
Yet to be recognized.
Yes. Yet to apply.
Yet to apply.
Yet to
Yet to apply. Now, what will be the case of those candidates?
Their degrees will be invalid, man. In view of Section 16.
Now, the critical date should be when he obtained the degree, number 1.
He appeared in the exam. He completed the course, my lord. Degree may have been issued a little separate, subsequently. That your lordship will find at page 28.
Yes, the
Where it is given.
effective period when he had pursued the course.
Yes.
Number 1. Number 2, when the application was given by the institute for recognition.
Yes.
And when was the recognition done and read with the notification? 6 months.
Yes.
These are the only points.
Yes. True. But what I am saying, my lord, This affidavit also does not state the clear picture whether the degree obtained by the respondent number 7 is valid or not. My lord, they do not say that. In another affidavit, my lord, I have annexed in the writ petition, their stand is a little different. May I take your lordship to that affidavit, my
Now,
lord?
what does the respondent number 7?
Respondent 7 says that I have passed all the degrees of the college as valid because it has been recognized, although subsequently.
No.
Because it was, my lord, the application was within the extended period of time. Notwithstanding the fact that, my lord, that extension is only for the institutions which were in existence on the appointed date.
Existence means
It was already established and started the court.
movement to say that rightly or wrongly he had a PhD from this Hailakandi thing, which was the former name of Sasibu.
Yes.
That means there is no dispute to the fact that there was an institute in the name of Hailakandi existing. Existence cannot be doubted.
No, existing, my lord, the crucial duty is existence on the whether on the prior to or subsequent to the appointed date. That is the crucial. The institute was not in existence.
Appointed date was 17/8/1995.
Yes.
And he has obtained in 1997.
Yes.
So, if it was 1995 to 1997, how did you pick out a case that was not or
It was not in
from the
existence.
appointed date he did not procure the decree?
No, the college was not in existence. College was not in existence. My lord, that your lordship will find it was established only on 31/12/1995. I have given the date, my lord. 31/12/1995.
31/12/1995 is the date of establishment of the college.
Yes.
And the appointed date is 17/8/1995.
Yes. So it was not in existence on 17/8/1995.
So what would happen to a college which has been established after the appointment? Will not get the benefit.
Under, my lord, section 14, the degree is of no value for appointment. That has already been clearly stated in the statute itself. So, my lord, as I pointed out, there are two classes of institutions as per section 14. One in existence prior to the appointed date. For them, my lord, the extension has been given, rightly or wrongly. And for the institutes which are not there, not in existence on the date of the appointed day, they have to apply for first permission, then recognition, then only, my lord, they can go for teacher's education.
You want to contend that since the Hailakandi was established in December 1995, which is after the appointed date, that means it was not an existing institution.
Yes.
Getting the benefit of the notification.
Yes.
Get the benefit of the notification is an institution which was existing prior to 17/8/1995.
True. Yes, that is the point.
And if for a new institution, unless you are recognized and given the, but what about the transitional period? What will happen to this kind of? Suppose what we have stated is factually correct.
Section 14 says, my lord, these degrees will not be valid for the purpose of appointment. He may, my lord, that way he can write in the, my lord, his letterhead, but that will not give him the right to get appointment.
Degree conferred by a body which was not even authorized. Conferred.
My lord,
But what about the degrees prior to which had come before the coming of LCT in 1799?
those are valid, my lord. Those are valid institutes. And, my lord, I have shown in the amendment the concessions have been given to the government institutes only by the amendment.
Not to private institutes.
Not private.
To get the benefit, you have to be an existing institute prior to 1995. That particular date.
Yes.
Appointed date of 1799.
Right.
Only for those.
True. My lord, I have some case laws. If necessary, I'll place, my lord. Otherwise, I can reply. Okay. My lord, only one affidavit I'd like to show, my lord. In the affidavit in reply, I had filed in the IA, my lord. There is the NCT has taken a different stand. Therefore, my lord, what I am on is that the affidavit filed by the NCT is not of, my lord, great value or help. There, my lord, it is said. I'll just one paragraph, my lord, I'll read that your humble.
What are you reading?
My lord,
Reply against the IA.
in the there was an IA for vacating the interim order because I'm continuing by virtue of interim order. In the IA, we have annexed against that, my lord, prayer. We have filed an affidavit. There an order. There an affidavit of the NCT is annexed. Affidavit was filed on 29/5/2023 in the IA 1185 of 2023. Or may I forward a copy? Affidavit option by the petitioner.
In that you have next.
Yes.
Where page?
Your lordship will find the judgment is at page 12. Affidavit at page 12, my lord. And I'll read one paragraph, paragraph 3. Page 13. That is a part of the affidavit of the NCT.
Paragraph?
Paragraph 3. May I read it? In respect of a different candidate, but of the same college. Yes, Aniket. In fact, my lord, this affidavit has been filed in a writ petition which is item number 7 today, my lord. In this bunch of cases.
That deponent is Pradeep Kumar Yadav.
Here, yes, my lord, Pradeep Kumar Yadav.
You want to read paragraph 3?
Paragraph 3. This affidavit your lordship will also get in the item number 7 when it's taken.
Yes.
That your humble deponent begs to state that in considering controversy raised in the petition, the deponent begs to state that B.Ed degree obtained prior to 15/6/2001 is not a valid degree. The Eastern Regional Committee NCT grants recognition to Dr. Shashi Bhushan Institute of Education, Lakribon, Bollarpur Bazar, Hailakandi, Assam by an order dated 15/6/2001. The respondent number 7, so and so, obtained B.Ed degree in the year 1997 and the certificate issued by the university on 4/4/2000, which is prior to the recognition of the NCT, and as such, her B.Ed degree is not a valid. So, in one affidavit, my lord, NCT takes this ground. In another affidavit, in the present requisition, here, my lord, given a vague reply. One aspect, my lord, may come.
So your, is it, you have stated that this college was established on 31/12/1995.
31/12, yes, my lord.
Is it disputed?
That is not disputed. That your lordship will find, my lord, in paragraph 6 of the of page 9. They have not disputed that. And a
The name Hailakandi was at the starting, or was Hailakandi an existing college?
no, it was starting
31/12/95, it started at Hailakandi.
as Hailakandi.
If it's not disputed, then yes.
Now, my lord, only
Now
one,
we'll come back.
one aspect, my lord, that may come to your lordship's mind, my lord, because there may be many students who have got such type of degree, and they cannot get any benefit out of degree for the purpose of employment. My lord, against that, yes, my lord, equity may demand that they should deserve some consideration. My submission, and I'll, my lord, refer to laws also on that. When, my lord, the law and equity are pitted together.
No, this statutory provision.
Yes.
Equity will not come in.
My.
Something is not provided by law. How do you recognize degrees?
I'm highly obliged.
If he has completed the argument, then I place. Lordship will kindly directly.
You only will hear you properly, but is it the fact that your college from where you had obtained your B.Ed
was established
on 31/12/1995?
31/12/1995. That was the recognition given by the SCRT. That is the SCRT has given recognition. That is the that college has been given recognition on 31/12/1995.
When was it established?
Established before that, because otherwise Lordship college cannot be recognized by the SCRT. On SCRT recognized on
No, you have to come up with something very concrete. You cannot go by assumption. He has made a specific.
Lordship. Before that, Lordship, in this matter, in these particulars, the controversy has been already settled by the single bench of this honorable court regarding the B.Ed degree of the petitioner and other person in 1997 of Hailakandi B.Ed College. That is prosecution institute of college has been already settled by single bench, and thereafter, Lordship, he has preferred appeal before the division bench. Division bench also affirmed the B.Ed degree of the petitioner, and the other person who has obtained from Hailakandi B.Ed College in 1997 is valid. And that is in affirmed.
What is the remand order then?
No. Remand order was earlier to that. Remand order passed by this honorable single judge was earlier to that, before this single bench has passed subsequent judgment before this honorable court.
After this?
After remand order passed. And
which case?
I enforced the copy of the judgment in my IA. And thereafter, against that order, he has preferred appeal. Appeal also dismissed. And before that, Lordship will kindly see section 14. The regulation, application have to file on the basis of regulation sent by the NCT. The regulation.
But if the issue has been settled, where is there scope for re-entering?
It has not been settled, my lord. I'll let him show, my lord.
And so.
And if it is also affirmed by the honorable division bench.
Before that, Lordship kindly record, Lordship, the order by which the case has been remanded has been passed on 9/8/2015. And the controversy which has been decided by this honorable court in WPC number 3214 of 19.
The remand order is what?
Remand order is of 9/8/2021 in WPC 3551 of 21.
In the earlier case.
Where case has been remanded to the director, the secretary to pass an appropriate order. Considering
remand order by this court.
By this court.
Yes.
9/8/2021.
Correct.
Here of page 73 of the petition.
Yes.
Hereafter, Lordship, is controversy regarding the B.Ed degree of the petitioner, including the person who has passed on prosecution instead of education Hailakandi, was subject matter of writ petition WPC 3214 of 19. Page,
That is not 73, that is 60, 65 of the writ.
Lordship. That is writ earlier,
The writ.
Lordship.
Yes.
Yeah, IA Lordship will find IA 1185 or 20.
Yes, yes, we have there.
Lordship kindly see page 21. Same BA degree has been under challenge.
Page
Page 21. Connector C,
21.
page 21 of the IA.
Yes.
Lordship will find same BA degree. Lordship want Govindolal Chakraborty, respondent number 7, and Suparna Sinha, respondent number 6 under challenge of Hailakandi BA College. That is 6 and 8, Lordship.
No, it's not from Hyderabad.
Wait. I will take your Lordship to the directly to the page 24 of the judgment, which analogous writ petition has been disposed of by this honorable court.
Just a- This 3214 pertains to Shivsan College.
Lordship.
Silchar College of Education.
Sopon
Silchar College of Education.
Kumar Sena, Govindolal Chakraborty, respondent number 7 is from Hailakandi BA College, same college.
And Sapon Sinha,
Sopon Sena is other college.
no, Suparna is another.
Lordship. Suparna,
But Govinda
Same
Chakraborty,
same college.
Oh.
Hailakandi BA,
R7 is from same college.
same college.
Govinda.
Same batch.
Okay.
Now I will take a look to the relevant portion of the judgment,
Yes.
long judgment, page 41.
What is the date of the judgment?
Date of the judgment is 5/4/22. Page 24.
5/4/20. Yes, okay.
Now I'll take a look at directly to paragraph number 31, page 41.
41.
Look, same judgment, page 41, relevant portion.
Yes. Yes, it's 41.
Para 31. May I read it?
Yes.
As it is clear from the annual report of NCT for the year 97-98, which prepared as per Rule 14(1) of the NCT Rule 1997, that the Executive Committee of NCT has taken a decision of second meeting held on 17/10/97 inter alia to allow the regional committee to take up the consideration of application of institution which was offering course before 17/8/95 received after 18/8/97. If they satisfied there are bona fide reasons for delay, having noted the constitutive executive committee NCT court would not brush aside or negate the decision of the state executive committee to cavalier or lordship, and to hold that their decision were not sustainable. Moreover, said decision was not college specific or any particular college, but said decision had been generally in application, which is evident from the hearing before referred case of Sunita Sharma as the college in reference of the said college as Dakhin Guwahati College, where this court has observed the last date for applying for recognition was extended till 18/8/97. In view of the above discussion, this court cannot question or doubt the decision of the Executive Committee of NCT. Existence decision of the Executive Committee of 17/10/97, hearing before referred letters and respondent prima facie leads to conclusion that those chain of events did take place as projected. In this said context, this appears to be a fit case where the court may presume that under section 114 of Illustration of the Evidence Act, that judicial and official acts have been regularly performed. It does not appear that the grant of extension by the NCT to Silchar College of Education to apply for recognition till 18/8/97 was done without due care and attention on part of NCT. Said act of granting extension of time thereafter granting the provisional recognition of the State College of Education by NCT cannot be held to be mala fide. Therefore, in this case, such act presumed to have been done in good faith without any personal ill will or malice. It would be appropriate to refer para 24 and 26 of the case. This is the point of the state industrial case law. This is not relevant. Now, para 34.
Yes.
Para 34. Moreover, the petitioner is the only assailed BA degree of the respondent number 6 to 8 as invalid. Nonetheless, although respondent number 5-6 has pleaded that NCT granted extension of time of application to be filed for recognition up to 18/8/97, by communication 29/7/97, and Annexure C of the affidavit in opposition filed by respondent of it, said commission has not been assailed. Moreover, in the absence of any challenge to the decision taken by the Executive Committee of NCT, it is second meeting on 17/10/97 to extend the date of MK application for recognition to the court is unable to hold that the said decision of NCT to extend the date of making application for recognition till 18/8/97, which can be presumed to be sort of post facto approval, cannot be said to be not in accordance with law. On such communication dated 29/7/97 was made by Assam University for circulation among the concerned college. It would mean that the period of 6 months provided in section 14(1) of NCT Act extended up to 18/8/97. Regarding contrary affidavit, which has been stated earlier, NCT has filed contrary affidavit, that has been discussed in F. It is not disputed that the contradictory stand of NCT was taken in their affidavit filed by proceeding in WPC number Iman, State of Assam, in the proceeding at Appeal number Iman. In the said proceeding, NCT stand was to the effect that the BA degree obtained by the Silchar College of Education prior to 11/8/2003 was invalid. In this case, NCT has given an explanation that on 11/5/2001, after NCT has refused to case recognition to State College, the concerned file number 1 was closed. Thus, the degree obtained by the student till 2001 was invalid. It was further explained that the Silchar College of Education applied again for recognition. State application was taken up by different file bearing number demand. After finding requisite compliance and all deficiencies, recognition was granted for the session 2023-4. That for all purpose. The case of Silchar College of Education was considered as a new recognition, and all subsequent records were maintained in the file number Iman. It was stated that previous file was not considered by the NCT while submitting this affidavit in opposition, for which the NCT has tendered unconditional apology. Court is unable to wholly discard say explanation unreviewable because the maximum the error inhuman. Thus, under the particular facts of the case, this court is inclined to accept the contention of NCT and their stand in this present case is held to be acceptable. However, this court has tended to add that no comment is being made on the affidavit in opposition filed by NCT in the previous two proceedings. No any opinion whatsoever has been expressed respect of judgment and order that was passed by this court in the said proceeding Iman. Thus, the point of determination is answered in negative and against the petitioner of WPC by holding that BA degree of by the respondent number 6, 7, 8 are not liable to be declared invalid, as the institution conferring such degree are found to have approval recognition from the National Council of Teachers Education. So this is the finding, Lordship, by the single bench. Now, Lordship, against that order, same point, what has been argued, Lordship, the college was not established before the appointed day, has been argued before the division bench. That the single bench has not decided this point, whether the college was in existence before the appointed on the appointed day. That has been the argument before the writ appeal. I have enclosed the writ appeal's order. Lordship will kindly see the order of the writ appeal, page 49. That is the ground in the writ appeal. Page 49. Tapan Kumar Sinha, same writ petition.
Yes.
Page 54 is the relevant. From 53 onwards will be relevant. It was contended by the Learned Council representing respondent number 6 that NCT had a power to extend the date of filing application.
Page 54 paragraph,
Page 53, last page.
page 53.
Lordship. Last paragraph.
Okay. Yes, correspondent.
It was contended by Learned Council representing respondent number 6 that NCT had power to extend the date of filing application for B.Ed college by virtue of section 12 of the NCT Act. On this ground, Learned Council for the respondent explored the court to affirm the impugned judgment and dismiss the appeal. We have given thoughtful consideration to the submission advanced at bar and gone through the impugned judgment and material placed on record. Statutory provision involved and the precedent cited at bar. Controversy that has emerged for adjudication by this court is whether NCT has jurisdiction to extend the date of filing application for appellation. Nonetheless, to say that as per section 14 of NCT Act, application for seeking granting recognition was required to be submitted to the regional committee concerned to such form in such manner as will be determined by the regulation. Manifestly, such application could only have been filed as per procedure prescribed by the regulation. Section 14 states within regulation, same regulation. There is no dispute that the NCT regulation were notified on 3/12/97. Before appointed day, there was no regulation, the procedure by which the application had to be filed. It was notified on 3/12/97. Thus, before coming into force and regulation, there is no prescribed procedure for educational institution to have filed application for seeking appellation with NCT. Section 12 of NCT Act enjoins upon the council a duty to take all such steps as may think for ensuring planned and coordinated development of teachers' education. In our considered opinion, recognition being an integral part of the duties defined under Section 14, the council is definitely clothed with the power to grant extension to the concerned college, at least during the transitional period. The NCT issued letters on 10/7/97, on 29/7/97, intimating the Registrar of Assam University Silchar to intimate the existing institution to apply for recognition by 18/8/97. It is further note that dispute that Silchar College of Education submitted the application for recognition on 12/8/97 within the extended period. Thus, the institution from which the private respondent acquired B.Ed degree, having applied for recognition within the extended time as provided by NCT, was fully entitled to take students and impart B.Ed degree course for precision, which commenced before 18/8/97. Respondent NCT by affidavit of opposition filed petition has affirmed the fact that a B.Ed degree obtained by the respondent number 6 was a valid degree. The position of law has been crystallized by the Honorable Supreme Court in state of EP versus Iman. Judgment referred by the Honorable Supreme Court in Iman, cited by the Learned Council for the appeal, and lays down the principle that UGC regulation would prevail in case of state act is not conformity with the same. There is no dispute of such proposition of law as laid down by the Honorable Supreme Court. However, the factual situation of the case in hand make it clear that Silchar College of Education has applied to the NCT for recognition of B.Ed degree course within time. Such recognition was granted, LBT after some delay. Honorable Supreme Court in Iman observed that many provisions of NCT Act could not be put into operation only after relevant provision or forms came to be prescribed in the rules and regulations. In absence of rules, an act cannot be enforced. In absence of rules, an act cannot be enforced. As per NCT regulation, were notified on 3/12/97, it would not have been possible for the college to apply for recognition during the period, which was thereafter extended from time to time. Be there at me, the students who have commenced B.Ed degree from Silchar College intervening period would definitely protected by extension of time. Iman, Learned Singular, after interpreting the factual and legal aspect of the matter, has dismissed the petition. In our view, impugned judgment does not suffer from any infirmity, warranting interference, and appeal which dismissed as being devoid of merit. Now, I will take a lordship.
Please talk about what is the Silchar College. The appeal pertains to the Silchar College.
Not only Silchar College, the Hailakandi B.Ed College.
So tell us where.
Lordship.
Issue of Hailakandi College does not exist.
Lordship. Respondent number 7 is Hailakandi B.Ed College.
No, that is the writ petition.
Lordship.
Here's the writ petition affirmed by the division bench.
That means
Division bench was considering such a degree from Silchar College.
Silchar College. That is also, Lordship, the Silchar College has been discussed, but whole petition has been, the judgment has been affirmed.
At least there is a, you can submit that there is at least one judgment of the current single judge, which has settled the issue.
Lordship.
And writ appeal was pertaining to another college, but that there is no the judgment of the Honorable Single Judge is still holding the.
Paragraph 2, Lordship. Paragraph page number 1. Lordship, paragraph 50 is 51.
51.
Lordship, paragraph 2.
Yes.
Middle portion, likewise, Lordship, got it, likewise. Likewise, challenge is laid to the BA degree obtained by respondent number 7-8 on the very same ground that the institution from the such institution BA degree was granted was not having NCT recognition BA degree, and this respondent was invalid and would not qualify them to the post of principal. That is highlighted BA college. May I take a look at the list of dates which have been given?
Yes, please. Yes.
May I take a look at there is number 1.
Yes.
That is, Lordship, the appointed date that is notified in the official gazette. That is the gazette notification. 1/7/1995. Lordship, got it. Second line.
The appointed date.
Appointed date. No, notified in the gazette.
Gazette notification.
Lordship. Appointed date is 17/95, date of Constitution of the National Council of Teachers Education, NCT Act. 17/95.
Date of notification.
Notification. Now, Lordship, regional committee were constituted, phase 2. 13 December 1995, notified. It was notified on 6/1/96. Regional committee where application up to be filed. Gazette of India, January 6, 1996.
Regional committee is constituted.
Regional committee constituted. 6/1/1996.
Yes.
This is notification for regional committee where application up to file. Now I'll take your lordship to the rules where the application up to file the form application. Phase 4, Lord.
Yes.
That is, lordship, rules we call National Council of Teachers Education Rules 1997, whereby application have to be filed. That is notified on 3rd December 1997. The procedure to filing application. Procedure is, lordship will find New Delhi, 3rd December 1997. Phase 4.
Rules. These are the rules.
This is rule by which application have to be filed.
And 97.
97.
Yes. What do you want to show?
From this rule, lordship, I want to say how to give the recognition, who will inspect the institution, everything has been prescribed in the rule, and what will be the fees, and everything has been prescribed. Inspection committee will be the member, everything has been noted. Lordship will find page 5. Every application made under subsection 1, section 14, last put, page 5. Every application under section 1, section 14 to the concerned regional committee for
Page five,
obtaining
which rule?
rule. This is rule, Lordship, page 4 and 5.
Page five, which part?
Rule, Lordship, 7, 8, 9, Lordship. Fees,
7.
last portion, fees,
Power 7 is power and duties of chairman.
Lordship. Now, 8, Lordship.
8
Every
is,
application,
8 is inspection.
Lordship. Every application, fees, Lordship, fees. Every application under subsection 1, section 14.
Yes.
Every application made under subsection 1, section 14 to the concerned regional committee for obtaining grade of recognition under the Act by an institution offering the intending to course, offering training, research education on after appointed day shall be accompanied by fees rates specified in demand. These are the procedure every have to file application. That is notified on 3rd December 1997. So how a institution can file an application without having any rules? That is why Supreme Court has said without a rules, act cannot be enforced. Now, Lordship, I will take your Lordship to the later to the Assam University, page 89, which has been already shown.
Page?
Page 8 of the compilation. Where NCT has not stated that you close the institution, you do not give them to appear in the examination. May I read, Lordship? That is July 29, 1997. Lordship got it?
Yes.
To the Register, Assam University. I am draw your kind attention in the facts that according to provision contained section 14, every institution offering course or training research education before appointed day, 17 August 1995, has to apply for recognition to the concerned regional committee NCT within period of 6 months from the date. Provision was said are applicable to all colleges, department education, and universities offering BA research education course. It is mandatory for all teachers taking institution other recognition from NCT. Due to lack of information about procedure, many of the college and department of education did not apply for recognition within this stipulated time. Procedure and norms and standards for recognition have already been notified in the Gazette of India by the Council. In order to provide a fresh opportunity to the applying to a college and department of education, last date of receipt of application for core regional committee of the Council has been extended up to 18 August 1997. In accordance with the provision of section 16 of NCT Act, after 17 August 1995, no examining body can grant appellation provisional or otherwise for any institution to hold examination, whether provisional or otherwise, for a course of training conducted by institution unless institute concerned has obtained recognition permission from regional committee concerned under provision of section 14 and 15 of the Act. Further, in accordance with the provision contained in section 17, the qualification in research education obtained pursuant to the course of training from institutions which fail to neglect to obtain recognition or permission under the Act shall be not be treated as valid qualification for the purpose of employment, central government, state government, universities, or in the school of college. It will thus seen that while universities cannot grant affiliation to a college of BA degree course cannot be hold examination in course of training offered institution unless institution concerned has secured recognition from NCT students pursuing the course of that unrecognized institution will suffer serious adverse consequences in the matter of securing employment. In view of the position explained above, it is urgent necessity for all colleges, university, department, education, BA, other research courses apply for concerned regional committee or NCT for recognition. It is requested you may please issue necessary instruction to all colleges affiliated to your university offering teachers education as well as to Department of Education immediately apply for recognition well before the last date 18 August 97. Here, the college has not been debarred to conduct the course. They state we extend the date up to 97, you apply immediately and notify the college. They have not debarred. Why it is relevant, I will place a judgment on this point that NCT has extended the date considering the fact that the procedure and the everything has not been come to the knowledge of the not only the colleges to the universities also. Hereafter, Lordship, the principal association has applied for recognition, page 12, and thereafter, Lordship, the recognition. Now I have given a chart.
This is 12/8/97. Your letter, the letter by the college.
Lordship. to the regional
Application. By Hailakandi.
Lordship. This is within the performer law, as per performer prescribed by them.
But once it has been
That is
decided,
existing college before appointed date.
no, the college in question, that issue having been decided by a coordinate bench, is there a scope for to reopen?
No. And that point has been, I have placed 2-3 judgment on this point, though of not of this court. All these facts has been discussed and came to a conclusion. Lordship will give a compilation where Division Bench of Allahabad High Court has categorically held that the procedure prescribed and everything has not been notified. How it will
No, those aspects, are we required to go? Those have been gone in by coordinate bench.
coordinate bench.
Division bench has affirmed the judgment.
Only for satisfaction of myself, Lordship, I am giving the judgment. That is a Lordship, the
No, the judgment by the technical judge is an elaborate one.
elaborate one. And before the such judgment regarding the transitional period, the Allahabad High Court, so many cases has been held. One Ekta Sukla's case, the division bench of the Allahabad High Court, single bench has said that the NCT has no power to extend the date of the application for recognition. Allahabad High Court in Ekta Sukla's case, division bench has held that if that is held, all the colleges and degrees will fall to the ground. The court has held, they fell to the ground, all the colleges and degrees of the universities. This is a degree by universities. Assam University, Silchar, fell to the ground. And they said that up to 2001 also it was extended. Up to 2001 also it was extended. And Ekta Sukla's held that up to 2001 also it is.
What is your age? Your age
My age, and the affidavit I have said.
and like your age? Age. You are presently holding the charge
Yes,
of the principal.
regular principal. Regular principal.
So what is the stay out?
59 looks.
What is the stay
Only
out?
1 year. Status
Regarding?
regarding looks
In the
the
post
order
office.
passed by the secretary.
Hmm?
Holding the post of principal, status quo order was passed. He has challenged the order passed by the communication. This is not an order. This is a communication by the secretary to the director. That is under challenge. Impugn order has not been passed to remove him, but the secretary has passed an order directing the decision to the director. That has been challenged.
So your selection was questioned only because of the BA degree. Now you say that the BA degree, the cloud which was there, that has been removed. Your BA degree is rated to be valid one. And in that case, in the selection, you were above the petitioner.
Above as one.
You are number one.
Number one. And I have only 1 year of, not 1 year. At the time of filing IA, I am 1 year. Now, what 6 months or 3 months?
That was what we were asking, your age.
3 months.
3 months.
Only 3 months.
And you are in the second nominee.
Second.
You are the second nominee.
Yes, ma'am.
Is there any other candidate from
No.
Shashi Bhushan which is who's Vishwanath? Mr. Purkashta. You have retired.
But they have challenged that degree certificate, my BEd certificate, because he
What
has
certificate?
BEd
Yes.
certificate.
No, but what locals do you have to?
Yes, sir, because at that point of time, when I filed the case, my lord, I was the regular principal. And she has to challenge my promotion order, as the regular appointment order as principal, on the ground that the master degree which I had, it was not as per law. And therefore, we have also put to challenge her certificate. That is also not as per. Because my lord, the honorable division bench, my lord, my learned friend has referred to the judgment of the division bench. The division bench itself, my lord, has in another case connected.
No, but you're locals now.
Yes,
You are a retired person.
because my lord, she is.
No, how do you continue your challenge?
Because my lord, we are challenging because I have he is getting the benefit, my lord, and he has.
Who are you?
I'm the elected person of that.
I know who are you. What is your locus to challenge? What do you get? Is this a public interest litigation?
Getting something, my lord.
Who are you?
Getting something is different. My lord.
By allowing your litigation, are you going to get anything?
Getting whether I shall get something or not, my lord, but he should not,
You,
my
you
lord,
should
get-
not persist with this kind of litigation.
because
It will be dismissed with heavy cost.
my lord,
First, you have to establish your locus.
the
That
locus, my lord,
if we interfere, you're going to get some benefit. You're going to get any statistic result. That is
the
all.
day when I filed the case, my lord, the day when I filed the
As on today, when the decision is
by
being,
this time I have retired, my lord. This is the admitted fact that I cannot deny. I have retired.
and
already.
if by allowing your litigation, you will get some pensionary benefit, some notional benefit, then also matter is different. How are you going to get any benefit?
That
This is pertinent to whose place?
item number 7.
Anything else, Mr. Uttam?
Only for my satisfaction, Lordship, I place the extra judgment.
No,
Page
not required.
Okay.
Yes, anything? Mr. Pukas,
Then other cases, where, my lord,
In this case, my lord, my generally give the reply, my lord.
but we'll complete it now. Ask him to come. In the meantime, we'll try to hear Mr. Pukas. You have to just establish your locus, Mr. Pukas, in maintaining the challenge.
regarding locus, my lord, at this stage, I have retired. That is admitted fact, my lord.
No, because of his continuance, if we interfere with his continuance, are you going to get any benefit? Will there be any change in your status, in your pensionary benefit or anything else? Nothing.
Pensionary benefit, as usual, it will follow.
You are getting the pension.
Not yet given, my lord.
That's nothing to do with this case.
Nothing to do with it because due to pendency of the case, they have not given also.
You're going to you withdraw your case, matter ends there.
Withdraw, my
Get your
lord,
pension.
I have no written instruction from the party to withdraw the case. That's why I'm withdrawing. Well.
It's easy for us. We'll dismiss it. Not a case to be argued.
And regarding, my lord, this case, my lord, at this stage, next case, my lord, what is there, my lord? It's item number
You are in which matter?
item number 9, my lord. My learned friend is also there. I speak, my lord. In that case, there's another development. Let me just impact.
You are in which of the matter?
And 9, 10, my lord. 10 is also there.
This was Mr. Goswami's case was item number
11.
Muchabir. And Bijan Nath is item number
7 and 8.
7 and 8. 8 why cases?
They have filed, my lord.
8 you have filed.
No, both. Lordship, in fact, Lordship, the 7 Lordship, I have filed a writ petition, and they have filed an interlocutory application for impleading in my case. Lordship, may kindly take up WBC 1740 of 2020.
No,
Just because there is an order.
4291 17 is Bijan Nath.
Yes, sir.
So item number
Item number 7, my lord.
7. You are the petitioner, Mr.
Yes.
Pastor.
Yes, sir.
And item 8.
Item 8, my lord, my learned friend has filed. Where I have filed the miscase, my lord.
Why have you filed the petition?
Lordship, 1750.
Because he has been debarred, my lord.
Lordship, his appointment was set aside by this honorable court. Thereafter, I was the second panel and panel candidate. State selection board Lordship processed after his setting aside of his appointment Lordship. They have also prepared appeal as after in dispute. Thereafter, the state selection board processed my file, and at the last moment, Lordship, when the director had sent the approval for from the seeking approval from the government, the response number 1 had filed an impugning order saying that my BA degree would not be valid. I have challenged that order, Lordship.
It is from same Sashi Bhushan.
Yes, yes. 1740.
And this honorable court has passed an interim order. Lordship may kindly fail the interim order because there is a stay order not to fill up the post on regular basis without leave of the court.
Who is running the show now?
Now,
in charge basis.
that stay order was in respect of regular selection. Now, Lordship, I was given an appointment in 2022
On in-charge basis.
on in-charge basis. And my in-charge basis again was challenged by my lordship, my learned friend Sakia, Rita Rani Roy. And there is an interim order, lordship. And against that, lordship, I again file an interlocutory application for vacation of the interim order. Now, lordship, the inspector of school is holding the charge on in-charge basis in our school.
The series of
And for regular
cases.
selection, lordship, there is a stay order passed by the honorable court not to appoint anyone without leave of this court.
And in the meantime, my lord,
Because I am already regularly selected candidate.
Mr. Chaudhary, you can, so far as Mr. Goswami and your case, so you can complete your arguments, what you want to make any response.
My lord.
And then we can pass over to Mr. Das.
Yeah, judgment of the second level, yeah. Then for judgment of the. Yeah, look at the judgment. My learned friend must have shown, my lord, that judgment of the division bench.
Yes.
Now, the only point, my lord, that needs to be seen is that what is the ratio laid down in this case? If we understand my lord, the ratio laid down in this case correctly, then my lord, perhaps everything will be clear. Now, my lord, in the writ appeal,
154.
issue is, my lord, at page 54. Before that, your lordship may kindly come to page 38 or my lord 37, last paragraph, because this is the foundation on which, my lord, the case has been decided. 37, my lord.
Yes.
Section 14(1) has been decided. I mean quoted.
Yes.
Every institution offering that, your lordship is read again and again, my lord. I'll read once again, if your lordship permits. Every institution offering the or intending to offer a course or training in teacher education on or after the appointed day. I'm stressing on these words. May, for grant of recognition under this act, make an application to the regional committee concerned in such form and in such manner as may be determined by the regulation. Provided that the institution offering a course of training teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months if it has made an application for recognition within the said period. Now, my lord, as I have already stated, my lord, these are two classes, my lord. Now, dates your lordship will have already noted, my lord. In this particular case, at paragraph 27, that they have been specified. Thus, as the NCT had extended the time for applying for recognition by virtue of the provision of section 14(1) of the NCT Act, the degrees conferred by the State Silchar College of Education in respect. I'm reading paragraph 26 at page 38.
Yes.
As the NCT had extended the time for applying for recognition by virtue of provisions of section 14(1) of the NCT Act, the degrees conferred by Silchar College of Education in respect of course conducted between 1196 till 11/8/2003, the date when recognition was granted, cannot be held to be valid. The facts there, my lord, is that the Silchar College of Education applied for recognition on 26/3/2002. And it was, my lord, established before the appointed date. Because, my lord, whatever has been laid down in this case is, my lord, with respect to an institution which was established prior to, my lord, the appointed date. Here, my lord, the Silchar College of Education applied for recognition on 26/3/2002. So, my lord, the ratio of a case, as your lordship knows, my lord, is to be, my lord, understood in the context of the facts of that case. Now, so far as the, my lord, issues that has been framed by the Honorable Division Bench at page 54. I'm sorry, my. The Division Bench order, my lord, and that starts at page 50.
Yes.
And the issue that has been, my lord, framed, your lordship will find at page 54, paragraph number 5.
Yes.
May I read it, my lord, paragraph 5?
Yes.
The controversy that has emerged for adjudication by this court is as to whether the NCT had jurisdiction to extend the date for filing of application for affiliation. Needless to say that as per section 14, the NCT Act and the application seeking grant of recognition was required to be submitted to the regional committee concerned in such form and in such manner as may be determined by regulation. Manifestly, such application could only have been filed as per the procedure prescribed by the regulations. There is no dispute that the NCT regulations were notified on 3/12/1997. Thus, before coming into force of the regulations, there was no prescribed procedure for an educational institution to have filed an application seeking affiliation with the NCT. There is, my lord, nothing wrong in this, my lord. And this is, my lord, in the context of the fact that, my lord, the college was established prior to the appointed date. Here, my lord, in the present case, we are concerned with a college which was established subsequent to the appointed day, and therefore, my lord, the ratio that has been laid down here and the issue that was decided here is not, my lord, does not cover my case. That issue, whether what will happen to a college which is established after the appointed day, that has not been determined in this.
But yet, granted by the college of the same batch has been declared valid. The ultimate result.
Yes.
If one is held to be valid by a single judge affirmed by the division bench, same decree by another person.
No, my lord, my submission is that, my lord, this issue has not.
The law at this point of time, the consequences have been made known.
My lord, the question is, my lord.
You are trying to distinguish the division bench judgment before a single judge.
No, I am not distinguishing, my lord. What I am saying is that
the ultimate consequence is holding the decree to be valid. Unless that judgment stands, can we even think of?
My submission, well, what I am trying to, my lord, impress upon your lordship is that.
No, you are trying to slow the discussion, but ultimately, what is the final result?
Final result.
The challenge which was made to the degree, that challenge has been negated. Degree has been held to be valid.
We don't decide in this issue, my lord.
Can we
and
reopen?
This issue was not raised, my lord.
Can you reopen?
This issue was not raised, my lord. That was not considered by the division bench.
Can you reopen?
Oh, my lord, your lordship need not reopen it. Because this is not a case, my lord, laying down the law that a college which has been established subsequent to the appointed day is covered by this judgment.
But there is a doctrine points which could have been part of the argument if not decided, is held to be decided and rejected.
So this has not even been, my lord, argued in this case. No point was taken in this case. This was not the issue.
There are case laws.
No, this was not an issue before the, my lord, division.
That is what is exactly the doctrine. Doctrine of constructive, the extension of doctrine of constructive res judicata.
My lord, my submission with your lordship is that, my lord, the issue that has been raised in my writ petition is not covered by this judge, because this judgment has not decided as to what will happen to a college which was established subsequent to the appointed date.
In that case, it is not incumbent upon those petitioners to knock the doors of the division bench and review or anything or go to assembly.
My
It's
lord,
the point.
so far as
It's
the,
the point which could have been taken up, not taken.
no, this was not a list between the petition.
Understood, but the point of law is the same.
My submission would be,
And the college is the same. Degree is the same.
this is Silchar College.
No, there are reference to the Hailakandi college.
Hailakandi-
We wanted to, we had that part clear. The reference was the Silchar college that there is reference to the Hailakandi college.
In fact, my lord, this the issue that I have raised in this writ petition, that is a subject matter of the division bench, my lord. There are also NCT has filed an affidavit that I was trying to refer to your lord. That writ appeal is,
In fact, that those inconsistencies stand in the affidavit of NCT, that has also been one of the point of discussion for the single judge.
now my lord, writ appeal 197 and of 2022, that is pending, my lord.
That is what?
That is on this issue, my lord, on the issue that I have raised.
197 by whom?
197 of 2020, that is the, my lord, writ appeal.
No, no, by who's the appellant?
Some other persons, my
I'm
lord.
the respondent.
He is there.
And the my lord, the this court in the petition has declared the certificate of the rejection invalid. And thereafter they have preferred the writ appeal. And in that writ appeal, there is no
Invalid on what ground?
same, my lord. And thereafter, my lord, in the writ appeal, my lord, after pronouncement of the judgment in the connected writ appeal, my lord, I have they have stated about the judgment, and this honorable court thereafter, my lord, in order to bring the distinction and to execute the issue, directly NCT to file affidavit. Thereafter, my lord, NCT has filed the affidavit in that judgment is pertaining to the Vivekananda College of Education, affirming the stand taken by them in the writ petition and the clarifying the issue that the college which were established after the appointed date are not entitled to get the benefit of action period. That is affirmed by the NCT in the affidavit pending writ appeal. Yes. And also I'm giving the judgment of the this is connected to, my lord, here another item is here connected with item number 9. But
जजमेंट तो ठीक है, सिंपल जजमेंट
But the retable 164 of 2022 is of a later point of time and disposed of on 28/4/2023. You are showing an order of which date?
Subsequent to
No, 23/9/21.
my lord, 33 2023, my lord, there is an order.
30.
33 2023, the order by the honorable.
But this is the
I'm
28/4.
I'm giving.
No, the retable at 154 is decided on 28/4. What has been stated by the Honorable Division Bench in view of the fact which arose before this court while considering retable 154 and the more particular affidavit filed by NCT in the state appeal Leonard Council IALM, NCT is directed to file supplementary affidavit.
Yes.
This was on 1/33/2023.
Thereafter, they filed the ticket.
No, 33 was the date. Thereafter, 28/4/2023, retable 154 has been decided.
No, my lord, it was made PAB prior to that, my lord.
See, this order of 33/2023 has not mentioned of any judgment. So judgment was not there. It has only referred to the facts of the case in substance. But your contention is that the issue which you are now trying to raise was not the issue while deciding Kaponsina and also by the deputy.
Yes, that is my case.
Can you show some judgment that we can reopen an issue which was not decided?
On that, specifically on that point,
The doctrine of soft silence here will come in or what?
my lord, in my humble submission on the fact, my lord, that it cannot be said to be, my lord, it can be
You can have some decision on doctrine of soft silence if it was not decided at all. No discussion. Then, but there are decisions against you. We can straight away give.
In fact, one of the other appeal also is that the final scale. The court revision bench may take a different view because this issue is not decided. Or my lord, Your Lordship, gives me some time to my lord, answer to your
We have
lordship.
given sufficient time,
That's true.
and these are some of the list matters. Can continue tomorrow,
Tomorrow, day
Mr.
after,
Goswami.
tomorrow, day after.
Tomorrow is the day after. Mr. Purkas, you would like to make your arguments now?
Yeah, please,
Then you can complete your arguments.
Yep.
But that first case we are not going to keep that alive. That is going to go. Second case here. One case he is retired already.
Okay.
You're not going to. This is not a good practice. And he's not going to get benefit.
Yes.
Had it been that he'd get some pensionary benefit,
No.
that's not the. Yes,
My lord, may I?
yes, yes.
Seven, my lord, is in.
That matter we are going to dispose this of the other one, which are not. First one. Short order. And the other one you can argue. You have two matters in which
1740.
one he is the petitioner, isn't it? where you have implemented justice.
He has filed an implementing petition.
It was hard,
Yes,
but
yes.
not decision has been passed.
He has not been implemented yet, Lord.
Not yet implemented.
Not yet implemented. I have also filed an objection, Lord.
Oh, you want to now argue on the implement application of
No, he has filed an implementing petition.
that is it. Without the implement application being allowed, we cannot give him an opportunity of hearing. So first you have to argue the implement application.
If the my lord, if the position is that man, I have been retired. The implement will be also subject to the same decision of the item
The
number.
implement is by whom? By an
By
existing
no, by same petitioner of the respondent
then
number.
vision na.
Same vision. That is the
Two
position.
cases gone. You have to now give assistance to Mr. Choudhury.
And regarding my lord, item number WPC 442/2020, my lord. In this case, my lord, I have
Which two matters does
Lordship may kindly take up WPC 1740, first item.
item number
WPC 1740.
174.
in that case I filed the IA, my lord.
1740.
Yes, IA 1155/2020.
And what is the next case? 4291.
4291.
4291 was the
Why
first
don't you
case.
take up 4291 then?
Uh,
4291 by him.
but the second one will be more updated, Lord. Second petition is updated.
Whatever, my lord, updated or
No, doesn't matter.
doesn't matter. It is the issue is whether
Dispose this of
Yes,
4291. Huh?
429.
in view of the retirement, it will be closed.
Only that. We are not making any observation.
Yes,
We are not causing prejudice to something which are
yes,
not decided.
yes,
What view will be taken in that case.
yes.
Third, the book be put as that is count for the petition, whereas the yes, who is appearing?
Assam University is there and NCT is there.
The secondary education.
Secondary school is there.
Come forward, madam. Right to the back seat. Whereas the Sarangi and Standing Council Secondary Education is present for as per number 1, 2, 3, 3. And H for here. And then Standing Council NCT is for the as per number 4, whereas MS Art Aircraft. Then Council Standing Council Assam University is present for as per number 5. And Mr. Das for
I appeal for response number 7.
6. The SK Das Council is present for the response number 7, whereas none has appeared for the response number 6 institute. Considering the subject matter of case which is pending since the year 2007, and also the development which has taken place during the pendency, this kind of disposal at the adjacent stage. There are the demands of the petitioner is with regard to the benefit granted to the respondent number 7 on the basis of a BA certificate, which according to petitioner is invalid. is the projected case of the petition that the respondent number 7 had applied for the post of principal of the Swarna Lakshmi Higher Secondary School, Narsinghpur, in the district of Kachar, along with the petition. Full stop. In the said election, the petitioner was initially appointed on 2/5/2007. Full stop. However, the said election was the subject matter of challenge in a writ petition instituted by the present respondent number 7, being WP 270/2017. In the same writ petition, though an order of status quo was granted, in the case of the petition that he had joined the services and therefore had continued. Full stop. The petitioner's case is that subsequent he could learn that the B.Ed certificate of the respondent number 7 from the erstwhile Hailakandi B.Ed college is not valid. Full stop. The state college, which was later on named as Shasti Bhushan College of Education,
Yes.
had issued such certificate even prior to the recognition of the institute after coming by the NCT Act. The present case was thereafter instituted for the direction that any benefit granted to the respondent number 7 on the strength of such B.Ed certificate should be withdrawn. The forecast of the learned counsel for the petition has, however, fairly submitted that the petitioner had retired on
Date, my lord, at this stage.
year
I'll give.
has
Retired.
already retired
Okay.
and was holding, and at the time of such retirement was holding the post of the principal.
No, my lord.
Subject is, his appointment was status, interfered.
Which one?
Vijayanath appointment was
In this
interfered.
writ petition, he has challenged my B.Ed degree on.
No, you said the status was granted, but you had to continue.
No, this is in respect of the other case, my lord. Other
No,
case.
we are taking 4 to 9 months.
Yes, Lordship.
Yes.
In that case, initially I was continuing, my lord.
Then
Thereafter, I was my appointment as principal has been interfered with, my lord.
that you have not said.
Interfered.
That writ petition was allowed.
Yes, Lord, by your lordship, by your 270.
He retired as a graduate teacher, my lord.
WPC 2706 2007.
The petitioner has retired
As graduate teacher.
from service in the meantime, and therefore, there remain the meantime. Full stop. At the same time, from Sri S.K. Das, the learned counsel for the respondent number 7, has submitted that the writ petition instituted by him, WP 270 of 2007, was ultimately allowed
On 13/2/2019.
on 13/2/2019, and thereafter, the petitioner was reverted to the post of subject teacher,
Graduate teacher.
graduate teacher, from which post he had retired from service. Sir, considering that the relief claim in writ petition is only for debarring or only for withdrawing any benefit which have accrued to the respondent number 7 on the strength of the BEd certificate which has been questioned, and the petitioner has also retired from service in the meantime, this court is of the considered opinion that no fruitful purpose would be served by continuing this petition. Full stop. Even if this court is also of the opinion that the petitioner would not get anything tangible by continuing with such challenge, which has only become academic in nature. In view of the above, the incident is closed. It is, however, made clear that no observation is made on the matter of challenge. And the next one,
Next one is WPC 1740 2020.
1740. IA is 1159
Yes, filed for impeding.
and 1740 was for what?
For Lordship, I have challenged the impugning order 24/1/2020.
What is
Wherein Lordship, the respondent number 1 has at the last moment Lordship rejected my prayer. Although state election board had approved my appointment as regular principal. Yes,
That has to be decided.
It has to be decided along with item number 11, my lord.
We will discard. IA will dismiss the writ petition. What is your IA?
My lord, 1155 2020.
Third, we prepare the form for the applicant by means of application has sought implement, has sought for his implement in WP 1740 of 2020. The the opposite party petitioner, who is represented by S.K. Das, has also filed objection. The facts projected by the applicant in this IA is that the writ petition as well as the applicant were candidates for post of principal of the Swarna Academy for Swarna HS School, the district of Qatar, in which the applicant was selected and appointed on 2/5/2007. The said appointment was, however, successfully challenged by present writ petitioner in WP 270 of 2007, in which this court had allowed the state writ petition by judgment and order 13/2009. The instant writ petition has, however, filed by the opposite party number 7. Opposite party number 7.
By the
Yes.
petitioner, by the petitioner.
Writ
because
petitioner.
Writ petitioner.
Opposite party number 7.
Opposite party.
Writ petitioner.
Yeah.
As he has not been allowed to hold, has not been allowed to has not been given the appointment as principal,
In charge, my
No,
lord.
as regular. As regular.
as principal by doubting the BA the the it appears that the applicant who applicant has already retired from service, and therefore the opinion of the court he will not have any it have not have any locus to maintain the present application by which infringement has been paid for. Accordingly, the infringement application then rejected would come. It is however made clear that the challenge made with the petition would be decided on its own merit. All right.
Lordship may take up item number 9, my learned friend will.
What is
covered-
9?
Already covered judgment is there, my lord. I have given.
9. What is 9? Who is for the other side?
Lordship 12, your lordship will take up on day after tomorrow along with that.
9. Who is on the other side?
No, my lord.
9.
That by 9, my lord, that it was object from the Vivekananda College regarding the appropriate benefit. So this may kind of investigate. If you obtain from the Vivekananda College,
So what the honorable single judge said that you said that the appeal is pending. What was the finding of the single judge on the issue? No, the
I am
mo-
appearing in the order has been given.
no, the moment you say that a writ appeal is pending,
That was that was
the single judge has held that the degree has been is invalid.
yes.
That is the subject matter of the writ appeal.
Yes.
And what are you telling here?
I was challenging the same degree, my from the same institution.
You are challenging the degree. You are terming that it could be invalid.
Yes.
And this has been substantiated by the finding of the single judge,
Yes.
which is the subject matter of appeal in the
Division bench.
who is for the private respondent?
My lord, as he has retired, my lord, he is not appearing.
Who was retired?
My lord, the private respondent here in my his
Then-
status, my lord. But my lord, at that point of time, my lord, had he not been selected, I would have been selected as regular principal. Man. Now I am working as well as in-charge principal. Man.
And how is it done? Why do you continue?
I will get the benefit, my lord, if I become successful. Man. I will be regular principal.
That's
Now
a
I'm-
different matter. This can we direct that them to make to the regular principal?
No, my lord. If your lordship holds that, my lord, the selection of the private respondent, my lord, on the basis of invalid degree is invalid. My lord,
At this moment, after this retirement,
my lord, then my
it has
lordship,
become academic.
lordship may, my lord,
Consider
adjourn
if it would not like to.
lordship may adjourn this matter, my lord, let the division may decide the, my lord, issue, my lord, then lordship may take up.
But then also, it will be fair. Somebody has got some benefit for few years, that will be pensionary benefit.
My lord,
And
I
you
am
are
not
holding-
getting the benefit.
You are holding the post of principal.
No, not on regular basis, my lord. In-charge
Exactly.
basis, my
That
lord.
that you can
I am not getting the benefit.
that
my
you
lord.
can take up with the authorities to make a regular appointment.
My lord, if you lost this, my lord, direct the authority, my lord,
We can direct that the post to be filled up regularly.
my lord, in that case, my lord, there will be competition again, my lord.
You cannot escape
I
that.
have participated in the selection process. One person
That
has been
selection
selected.
process, the person who was selected, he was appointed,
The selection
he had
is there.
retired. His retirement, after his retirement, will be very difficult for us to interfere with. How long did he work?
Around, my lord, 1 year, my lord.
What benefit he will get? Nothing. Little bit of interim announcement in the pensionary benefit.
But I will get the benefit, my lord.
Not from that.
Even if my lord, from a present date also, my lord, I will get the benefit. That I have no objection if the private husband is given the pensionary benefit, but my lord, I should be promoted as regular principal, being the my lord, elected candidate, having the
That then we'll have to come to a finding and give a finding that the selection and appointment of the private respondent was not in accordance with law.
yes, ma'am. That is why my lord, let the better.
And in the meantime, many more candidates have become eligible. You have to face the competition. What's your age?
Age.
If you have less service left, it's better to leave this case quietly so that you also retire by interest.
My lord, my age.
59.
No, Lord, I have age.
Huh?
That in 2017, my lord, I was 45.
Oh, you have long,
Not that old, my lord.
17, 45, 17 to 7, 47,
52.
You're a young man who participates in this election
My
process.
prayer would be, my lord, let this
You will have
situation-
experience of having experience.
let this situation be pending, my lord, till that.
Is there any interim mode?
No,
Yes. And there is no embargo upon them. You can go ahead with this election. Why don't you go ahead? Madam, Charanti, you notify this election. Fill up the post on regular basis. There is no embargo by this court. See, the earlier principal, his appointment was put to challenge. In the meantime, he retired. Even if we hold something else in the writ petition, you are free to go ahead with the first. He'll get a fair chance. Consider his experience in the meantime. You make an application that since you are the panel number 2 and you have the challenge and he has retired, they can consider your thing for regular appointment.
Item number 12, my lord. In item number 12, my lord, my medical leave was not sanctioned by the inspector of school.
Why is it connected?
My lord, because my lord, in my place, my lord, the private student has been appointed. Her degree is from my lord, prosecution, and it was not recognized. That is why it has been connected. But my lord, another aspect is there. My medical leave was not granted, and there is a 19 days of service break has been shown in my service book, my lord. That is why, my lord, that is also under challenge. And that aspect, my lord, Standing Council, Secondary Education Department, they have to address this normal court, my
Yes,
lord.
what just said regarding medical leave 90 days? Have you filed any affidavit? It's a new matter. File your affidavit.
But Lordship, this will be applicable, Lordship, this is only for insert. But if WPC, if WPC 1740 is decided, that is for regular selection of principal, because I am already regular. My name has already been recommended.
Okay, we'll have it.
Only for, yes.
Different court.
Different for-
Okay. Item, which one?
My lord, item number 10, my lord.
No, 7, the IA has gone. 7 main case is there, correct? 8, the case is closed off. 9 is there. 10, 11, 12. Right?
Yes.
In respect of 10, my lord, this is a different college, my lord, Baihata Suryali College, my lord, and we have filed our counter affidavit in another expedition, WPC number 3221, my lord, in Kamdev Sharma, my lord. So that will be covered, my lord, in this case.
But Kamdev Sharma, that matter is pending on.
Yes, pending, my lord.
Is it listed today?
No, my lord, not listed today.
Then you can have this case along with Kamdev Sharma.
Yes, yes, because same college, by
Same college, I think that
Same
will
college,
be
my lord.
The
item number 10.
My lord, the copy of the affidavit may be provided to me, my lord.
he has no locus, lord, to file this.
No, you give a copy of Kamdev Sharma.
No, I am in the response of four laws.
I don't know, I'm asking.
Yes, sorry.
I don't know.
In this case, also, this
So this
matter will be
case-
segregated. Item number
Yes, so
10.
this case has been listed along with few other cases today. Few other cases today from the Learned Council for the part have submitted that this case required segregation and heard along with WPC
321.
321 of
2021 matter.
21. Written by Kamdev Sharma versus State of Assam.
321.
That is 321 Kamdev Sharma, which pertains to the same college, namely
Byhata BH.
Byhata B.Ed College. The Alam further the Learned Training Council NCT further submit that in WPC 321 of 2020 the affidavit in opposition is filed, which would also cover the present case. Sarah, in view of the same format, that a copy of the affidavit be served upon both the broadcaster, Learned Council for the petition, as well as ADECA, Learned Council for the private one. And these writ petition may be listed along with WPC 321 of 2020.
Day after tomorrow, my lord.
Date may be fixed.
We do not know that matter in the next week.
Next week. Lord.
Next week, for 3-4 days are holidays.
Lord.
Next Thursday we can have.
Yes,
But that
on 7th of my lord.
no, we cannot give a date. That record is not with us.
Next week, Lord.
Next week.
Next week. Obliged, Lord. Item 12, my lord, my friend will be directed to file affidavit, my lord, because my lord,
12 will be covered if that matter it depends on Mr. Mr. Dasan.
other issue, my lord, regarding my break,
This is for
my
only
break in
instance
service, my lord.
Because the regular.
If we see that there is, madam, you can get the instruction. There may be an
My lord.
this is good. पहले को पर this yeah. This you can take it back. I think Goswami, some papers. Mr. Purkastov, there may be some papers you give the afternoon. Yes.
Also, in this case, on the last occasion, we were directed to get a cabinet memorandum, your lordship, regarding the 65 years old, whether it was only for educational institution or for all institutions, we should cover the research institutions like the institution where he is working, your lordship, Omio Kumar Das Institute. That, your lordship, this cabinet memorandum, we have not been able to procure, your lordship. The department has sought some time for this.
The problem is that the issue raised in this petition is that whether the petitioner, who is also a professor under Romeo Kumar Das Institute, will get the same age of superannuation as that is for other regular professors, my lord. In fact, my lord, the government of Assam, the cabinet has taken the decision to raise the age of superannuation of all professors of the state to the age of 65 years. The petitioner, before joining in this institute, was working in North Bengal Institute, North Bengal University. Had he been working there, my lord, he would have retired at the age of 65 years.
because it was a promise on the part of the authorities that UGC will be followed. And as per UGC, my lord, it has been 65 years for across all the professors. That is the issue, my lord. The very short issue. Since records are not there, Lordship, may I pray that matter will be taken up on 7 because petitioner will retire in the month of January, my lord.
February 24, your lord.
We have time.
Lordship, one more week, your lordship, not 7, the next week.
We have time. What do you teach?
My lord,
What is your subject?
my lord. Subject is policy. Here's the complete. I'll just give me a second, my lord. Political science, my lord.
Heard Chakraborty Senate Council petition. Also heard T.S. Hazari Kadani State Council, who, however, submit a certain instructions are to be used, are to be obtained by him, for which he prays for some more time. Please, Tom. Yeah, let us
And 12th of September in that case, my lord, on the hearing day.
Or 14.
11th of September.
11 is a, my lord, in the case of hearing day, my lord, Lordship can decide them. The only issue is whether the petitioner is covered by the cabinet memorandum, like cabinet decision.
12th of September.
I'm deeply obliged. my lord.
Obliged.
Yes, madam.
May I plead your lordship? Lordship, I am on behalf of S. Dr. Lordship. Lordship, in this case, Lordship, further some time may be given for instruction, Lordship.
What is the matter?
My lord, matter relates to, my lord, non-counting of the services, my lord, on which, my lord, he was terminated from his contractual engagement illegally. This honorable court, my lord, held that, my lord, that is illegal and directed the authority to reinstate him forthwith. Now they are counting my service from the date of reinstatement. That break period they are not counting, for which, my lord, I am getting less salary than the other similarly situated person. So, my lord, my case is that my service should be counted from the date I was appointed, and I should be given the salary equal to my counterparts. My lord. That is my limited grievance, my lord.
Yes. Instructions are not there.
No, Lordship.
You
Lordship,
want to pay?
yes, your Lordship.
How much time?
2 weeks may be given, Lordship.
PNRT.
Lordship.
What is the name, madam?
J. Bora,
Jebora.
Lordship.
You're for S. Or
Yes, Lordship.
hard 3 8 take care. Turn it down for the petition. You're good by order by
My lord.
listed by orders by
Because, my lord, this was not listed for a quite long period, my lord, and that is why it was mentioned, my lord.
MS Jebora. Turn it down. Accident for Panchayat and Rural Development Department. Submit instructions are awaited and what praise for some time. Sarah. Something that is pending. He is of the year a final of 4 weeks done to enable the respondent to furnish this of
Fix a date, my lord. Otherwise, that will not be.
Yes, madam, can we fix the date?
After 4 weeks, okay.
Lordship, 29 September.
Yes, we have not paid time.
Obliged, my lord.
Obliged, your lordship.
Matter, we have filed an affidavit only today, madam. Probably on record. We have a.
Will like to file return there.
Lordship, yes, lordship.
The Gokoi, the standing concept for us has happened that the affidavit in opposition has been filed, which however has not been tagged to the record.
D. Mohanto.
The amount of when it comes, for the petition, however, that sometimes done to obtain instructions with regard to filing of return to affidavit for my offense. There are list of doing along with the affidavit of
Lordship, a date may be fixed.
list on on 18th of September. 18th September. Always. Yes.
Lordship, Assam Police Department is divided into two different wings, armed branch and unarmed branch. And I am working as a constable in the armed branch of the Assam Police. And I have approached this honorable court with a prayer for direction to convert my position from armed branch to unarmed branch. And such conversion is necessary for the promotion to the higher post. Although this two stream has a separate way.
Can you shift?
Yes,
Can you migrate?
there is a provision.
For migration?
It is called an official term is called transfer from one stream to another stream. And there is a provision. Lordship, this conversion.
Do you meet the criteria for such?
Yes, that is.
Mr. Sutia?
We have filed an affidavit, my lord, as per affidavit, my lord. However, there, my lord, there is a provision. There is a as per provision and there is a qualification eligibility criteria also there. How many years he has to work as an armed branch, thereafter he can convert to the unarmed branch. Now petitioner, he wants to convert from AB to UD, unarmed branch. So our affidavit here, my lord, after one case was for Oloknath, there has been, my lord, enacted here 110/2020. Some occasion I appeared in this case whenever matter was listed before court number 1. Ultimately, that was disposed of, and according to the my lord, case also, my lord, there is a procedure, and our lordship can see our affidavit, my lord. Affidavit is clear. Lordship, our affidavit.
Is it possible for you to consider
That way, some criteria is there, and subject to availability of the post.
No, does it meet the criteria?
There one
criteria is there, police manual criteria is there.
No, does it meet the criteria? Does he fulfill the criteria?
No, my lord, his seniority is below than other person.
No, this is absolutely wrong.
No. My lord, I was kindly see our affidavit, my lord.
You say that there are certain hurdles you cannot consider. Have you filed your rejoinder?
Yes, that also their affidavit, page number 89, Lordship, it is their affidavit, page number 89, clause 14.
Page 88, my lord, paragraph 12 also.
That fact is not disputed, undisputed fact. I am not trying that. Yes, if I meet the criteria, I have submitted my willingness. That has been forwarded, placed before the screening committee.
Which page?
Page 88.
80.
88.
88, yes. Paragraph?
Paragraph 12, my lord.
12, yes.
With regard to a statement made in paragraph 12 of the petition, the deponent be expressed there, on the basis of seniority cum merit, a list of willing AB constable have been prepared for conversion. Accordingly, the Assam Police Headquarters notification dated 5/4/2022 conveyed by memo dated 5/4/2022 selected 150 number of AB constables, public women
You tell
constables.
us one thing, just one thing. Is there any legal hurdle or difficulty for considering his case?
They will do it in terms of when his term will come, they will do it.
So
Because
it is in seniority basis.
seniority basis. That's why case, my lord. After passing this 110/2020 case, my lord, division bench passed this order. They are preparing the list, my lord. If the name of the petitioner is not included in the list.
No, it is lordship. One issue is to be, I need to clear that the circular says that every year, 25% of the total sanction strength of the UB constable shall be fulfilled by way of conversion from the AB constable. Accordingly, last year they have converted 150. All right. And this thereafter again they have invited willingness, and I have submitted. And circular says that if there is a vacant post, only then the willingness shall be invited. Accordingly, considering the vacancy in the UB stream, willingness was invited, and I have submitted. Now the next step, what is that should be placed before the screening committee. And if screening committee find that some people are eligible, they will be converted. Some people are ineligible, they shall not be converted. This is the process. I am not contradicting anywhere. I am telling that already the willingness have been filed one year ago. No decision has been taken. In page number 89 of their affidavit, Lordship, clause 14. It is undisputed fact. I am not telling that this court shall direct them to convert me. If I fill the criteria, the screening committee is satisfied that I have fulfilled the criteria, only then my position shall be converted.
Tell us one thing, whether this conversion which you are seeking, is it based on some seniority pattern?
Exactly.
And depending on your seniority, they will consider your.
They consider,
Definitely,
madam. The paragraph is not completed. Paragraph 12 is the second paragraph. As the last paragraph, paragraph 12, the last portion, however, conversion to a continuous process and carried on from time to time subject to requirement vacancy position of that time.
You just tell us one thing, whether in the list which you have prepared for conversion, does the name of the petitioner, is his name there?
No, madam. His name is not
Earlier
included.
list.
The 150 selected candidates, AB constable was prepared. The petitioner name is not included.
No, in the present exercise, which you are required to carry year-wise,
Year-wise.
in the present exercise, is his name there in the?
No, my lord, not included. If there are left out candidates in the, this is the position. If there are left out candidates in the recommended list who could not be converted due to lack of enough vacancies, then they will be included in the next year along with fresh candidates who submit willingness for such conversion. No fresh willingness is required.
Have you made any statement that person junior to you has been given the benefit?
No, sir.
No, I am not on that point, Lordship. On last
No,
year,
why we are asking for the categorical statement that the list has indeed been prepared, where your name is not there.
and last year my name was prepared. It was bona fide list. But the circular says that every year list has to be prepared. And if they prepare this year list, because the 150 people, they are senior than me, they have been converted. Now my turn will come.
You consider his case?
Consider, they will consider as per norms.
In Lordship, my last submission is that in terms of the paragraph 14 of their affidavit and 16, this petition may be disposed, giving them a time frame that within that period they may prepare a list. And I am not telling that my name has to be included, because I am confident that my name will come, because merit comes seniority wise. I name.
As that Madhukar for the petition also heard it should be done it. Petition is preparing for all the responsibilities. Considering the subject matter of this petition and also the nature of relief, the same taken up for disposal at the itself. Have you seen? The petitioner is presently working as an armed branch constable under the Assam. The Assam police is divided and has two different branches, namely armed branch, EB constable, and unarmed branch, UB constable. Correct. Shri Madhukar, the learned counsel for the petition. How many of you are there?
9 people.
And for the petitioner has submitted that each year, certain numbers of, each year when the vacancies of unarmed branch constables are filled up, 25% are allowed to be transferred from the armed branch in accordance with seniority.
Yes.
And the other procedure laid down in the rules. Full stop. It is the case of the petition that though they had submitted application for their transfer to the unarmed branch, those that have not considered proper perspective. The Learned Counsel according submit that a suitable direction is required given consider cases of the petition for their transfer from unarmed branch to unarmed branch. The learned senior government, additional senior government, in his usual fashion, has submitted that every year that the exercise for transfer from armed branch to unarmed branch is done by following the rules in which seniority plays a major part.
Seniority का merit.
Then
Merit
whether
also there.
he submits that the criteria followed is seniority come merit, and if the petitioner fitted the same criteria, there is would definitely consider. He, however, submits that the previous exercise for such transfer, there was no deprivation as such of the petition, as there were senior persons above them. The State Council, however, not opposed to the proposal of the court that a direction for the consideration may be granted for filling up the vacancy next exercise if they otherwise meet the eligibility criteria. In view of back and the broad arrived at the bar by Learned Counsel parties by direct consideration of the petition for their transfer
Along with
from
that,
unarmed to armed branch, which however has been done strictly in accordance with the rules and the criteria laid down for such transfer.
In the circular number 1 of 2021, it is page 71 of my petition.
Learned Counsel has also referred to circular number 1 of 2021, laying down the guidelines.
yes. Guidelines, but yes, circular number 3 dated 3/12/2013.
3/12/2013.
13 years guidelines.
No, Lordship, that circular is
Don't write.
superseding that circular.
Don't
It
write.
is the latest one.
Why we have said the rule?
And Lordship, my one more submission. And the time frame may be given.
Time frame we cannot say.
Lordship,
And the next exercise we have said.
next case is otherwise this 1 year.
No, time cannot be done.
And we have said next exercise.
Next exercise, they are not taking, that is why.
In
that is why
accordance
my
with the
petition.
rules, we have said.
The rule says that the 25% in every year, 1 year has been elapsed.
We have said in accordance with the rules, they have followed the rules. If they do not follow, you come up with a contempt.
Okay.
We have mentioned the rule.
Then Lordship, my last submission that this clause may be mentioned. Clause number 10 of the Circular
As per
number.
guidelines, my lord, because my lord, he hasn't made out that the junior person has been
No, no, this
converted,
is
he
not my
converted.
case. This is the
There is no case.
miss.
Obliged.
Yes, what is it?
There is also the selection and appointment of post of administrative officer.
Regarding
Yes,
requirement of
taken time.
15 years, my lord.
Which I have heard, I think, for some time.
Yes,
Lordship
yes.
has heard.
My lord, this, I think, I just refer my lord.
Oh, we have not heard you. You,
Yes, 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 yes. The Assam Ministerial, my lord, Assam Ministerial District Establishment Service.
oh, those, that part.
Yes, yes. My lord, I just like to just point out some points, my lord. Very important, my lord. That is rule 6, my lord. My lord, before that, my lord, my honest stated that I have completed 13 years, 10 months. Actually, not 13 years, 10 months, 14 years, 10 months, because whole 1 year is to be treated, my lord, as per law. The joining, but it is there. It is provided that 1 year of joining shall be treated as complete year, irrespective of the date, month of his or her joining.
You're reading to
That is the
this book,
yes, yes, yes.
same book,
Yes. Page 194. 19.
Yes.
Yes, 6, my lord. Recruitment. The recruitment to the service shall be made by appointing authority according to the procedure laid down.
Yes.
That is Saristadar, my lord. Now it is changed. I will come later on, my lord.
Yes.
By selection from amongst the person who must have served 15 years in the deputy commissioner of the establishment and have experience of different. My lord, after that, my lord, provided that 1 year joining shall be treated as complete year.
Where?
That is my lord, provided, my lord.
Provided what is there?
Yes,
it?
provided that 1 year of joining shall be
Not
treated.
1 year of joining. First year.
Yes, 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 that's good.
There is a difference between first and one.
Yes, yes, yes. The first year of joining. The first year of joining, my lord, whole year will be treated. That is whole year. Now,
Provided the first year of joining
shall be
shall be treated as complete year, irrespective of the date and month. Only the first year.
Yes, that's good. That is.
Then also you are not meeting 15 years.
No, yes, ma'am. My lord, now, my lord, page very important, my lord, 198, my lord, because that clause 6 is now changed, my lord. That is considered by probably by the 8A, my lord. Note, your lordship got it, my lord.
8.
Page 198.
Yes.
Note, my lord, 8A. My lord, prior to that, my lord, in the principal rule 7, sub-rule 7, not found by any amendment or by notification as mentioned in the list of amendment. However, sub-rule 8 inserted by the notification so and so dated 2nd March 2009. My lord, 8.1. This is very important. The post of administrative officer. Now, this is for administrative officer, not Saristadar, man. Because now it's changed, man. Administrative officer shall be filled up by the selection from amongst the persons who have served at least 15 years of service in any deputy commissioners. Now, here, my lord, the must word has been deleted. That is very important.
What is it?
The must word. He must have completed 15 years. Must have served. Here it is kindly see. Have served at least 15 years of service in any deputy commissioner's establishment and have working experience of different branches in general and the establishment of branch in particular. Now,
what is the meaning of at least?
Yes, I understand, my lord. At least, my lord, but that there is a reason, my lord, why must have been deleted.
Where was must?
Must was there in 6, my lord. And page 194, my lord. There is the rule 6, my lord. In the advertisement also, this must what has been used. Yes, rule 6, page 90. Must have, sir.
No, this is a different post.
No, my lord. Yes, my lord. Now it is administrative officer. Here in this post, my lord, I am holding administrative officer's post, my lord. Administrative officer post. Now, my lord, I would like to take your lordship to page 205, my lord.
That is not going to make it mask or at least.
Yes.
At least also
yes, I understand, my lord. But mask was
205.
yes, now 205 rule 15. Now, power rule 15. power to dispense with or relax any rule. Where the appointing authority is satisfied that the operation of any of these rules may cause undue hardship in any particular case, it may dispense or relax the requirement of the rule to such an extent and subject to such a condition as it may consider necessary for dealing with the case in just and equitable manner. Now here that is one of my submission, madam, because first of all, madam, the must word is not there. Although in the advertisement, administrative officer word is there, but they've used the clause 6, my lord. That is must
Where is
word.
the advertisement?
Advertisement page 24, madam. Page 24 of the writ petition.
Here for R, respond number.
Yes, that's one number 5. Page 24, madam. You already
Just a
got it,
minute,
the
just a
advertisement, madam. I am on the advertisement, page 24, madam, in the writ petition. Annexure, I think it's annexure 6, madam. Applications are invited from the eligible candidate in standard form for filling up the vacant page 24
of the
of the
writ
petition.
Yes.
Yes. An application are invited from the eligible candidate in standard form for filling up the post of administrative officer in the amalgamated so and so. Next paragraph, my lord, the candidate must have served 15 years. Here, my lord, the advertisement use the administrative officer. Now, if the word administrative officer is there, my lord, then clause rule 8A should have come, my lord.
Now we will consider at least.
Yes.
We will not go by the
Yes.
advertisement. We can go by what is there in the rule.
Yes. Now, at least, my lord, that is not that means it is not that it is absolutely must, my lord. That is what my
At
humble.
least what is the meaning of at least?
At least 15 years, because my
At least
temporary.
is minimum 15 years.
Yes. So, but if my temporary service are being considered, my lord, because from
You advance your argument on that temporary service.
yes, yes. So
What
just before that, my lord, I just like to point out this. Now, my lord,
When did you join as the ad hoc?
in 2004, my lord.
2004. Joined on honorarium.
Yes, yes. May I please number?
I'm substantively appointed when?
Subsidy appointed on 26 to 2007.
R5 substantially appointed
As section as section assistant. Junior assistant, junior.
junior.
Yes. Now that is my case, my lord. Now I typically lost it, my lord, because after all, my lord.
Can you tell us what are your cases?
Yes, yes, my lord. My lord, there is one judgment, my lord, of Himachal Pradesh High Court, my lord, also division bench. Although this matter regarding pensionary grant, my lord, but here it discussed, my lord, the other why it should be considered, my lord. My lord, this is regarding online. I have collected 2020, my lord. Qualifying service rendered prior to regulation in any capacity, including ad hoc basis, has to be counted towards qualifying service, even if the service is not preceded by a temporary or regular appointment in a pensionable establishment. No discrimination can be made in the employees who rendered service prior to the regulation in the capacity of ad hoc employee. My lord, I will just like to
Use the division bench, it's not division.
No, my lord. Some discussion is there regarding one division bench judgment, my lord. Paragraph 6, my lord. Next page, my lord. From 6 onward, my lord.
Paragraph
6, my lord. Next page, my lord. In fact, I may read, my lord, a small paragraph. Six, 7, 8, 9.
Yes.
In fact, the issue posed in this petition is no longer res integra in the view of the decision rendered by learned single judge in this case in Parasram versus State of Himachal Pradesh others. 2009 HP 887, where it laid down that if the ad hoc service is followed by a regular service in the same post, the same service can be counted for the purpose of increment. Now, my lord, next one, my lord, 7. Further, a division bench of this court, LPA number 36 2010, entitled Sitaram versus State of Himachal Pradesh and other, decided on 15/7/2010, after placing reliance upon Parasram case Sopra, held that it is also settled principle of law that any service that is counted for the purpose of increment will count for pension also. To that extent, the appellant is justified in making submission that the period may be treated as qualifying service for the purpose of pension also. Now, my lord, after this, my lord, paragraph number 10, I will read, my lord. The respondent have been benefited by the service rendered by the petitioner in the heyday of her life in less salary or ad hoc basis. Therefore, there is no reason not to count the ad hoc period in case it has been rendered before regularization. If the same is denied, it would be highly unjust, impermissible, and irrational to deprive such employee benefit to the qualifying service. Now, these are the part of finding, your lordship. Next is small judgment, page 16, my lord, paragraph 16, my lord.
Yes.
Paragraph 16.
1/6.
Yes. In view of the aforesaid discussion, I find merit in this petition and the same is accordingly allowed. The respondent are directed to grant benefit to the entire ad hoc service rendered by the petitioner towards seniority for all intent and purposes, including grant of proficiency, set up assured career progress scheme benefit, and all other consequential benefit following thereof within a period of so and so much. Well, this is my humble submission. At least is on record, my lord, that I have been working since 2004. And backdrop is also required to be taken into consideration. It was a newly created district, my lord. There was no employee. I was the first employee, my lord. It was such circumstances, my lord. I had to look into everything in the district, my
Mr. Chaudhary, if the issue would have been the respondent number 5 century,
Yes.
pertaining
Yes.
to
Yes.
your regularization, your increment, your promotion. We are in the context of a competition.
Yes.
Which is open in the market. Now it has laid down qualifying service.
Yes.
Qualifying service is 15 years.
15.
Now, if you say that I had rendered my service for some period on an ad hoc basis or
Temporary.
in-charge basis or some other basis which is not a substantial appointment, and this period should be counted for my career in progression, like your maybe a pensionary benefit or increment. But this is a fresh appointment.
Yes.
It is not even a promotion.
Yes.
You are supposed to have that experience or in an office so that you become eligible for consideration for such appointment. And if we tinker with this, and you have shown relaxation, relaxation has not been, that clause has not been taken into recourse. If they have said that yes, we invoke the powers under clause 22 and relax, that has not been done. Power is there, but power has to be exercised. And
That
for
is not- that
exercising,
is the respondent.
you need to follow the due process. That has not been done. And second, the most important point is that regarding the rule, where is the rule?
Yes, ma'am. Page starts from page 198, ma'am.
The consideration.
Yes.
Most important is the consideration. Consideration has not said that your previous services have been taken into
Yes,
consideration.
ma'am. Yeah, that is.
If that was the stand, then would have had different grounds of defending us. Now the defense has to be on the face of what has been stated in the order. We cannot go here and there. Mahinder Singh Pal, Govardhan,
Yes, yes.
everything has laid down that you cannot improve a case by way of an affidavit or afterthought. Whatever is there on the record,
yes,
you have to defend. Now the justification is given that on the date of the consideration, you fulfill. That consideration is the wrong one. They could have had many other things yes, we count his past experience, maybe on ad hoc, almost that far we count it. There is one. We relax the rule, make it.
Yes,
him-
because
that
power
was-
is there.
Those have not been done.
Yes. But that is not my part, my lord.
No, that is,
Yes, yes. That is my humble submission, my lord.
yes,
So-
anything,
Lordship. Opponent number 3 and file affidavit, lordship. In
who is
affidavit,
free,
Deputy Commissioner, lordship.
what is your stand?
And his lordship, para 4 of our affidavit in opposition, lord. Para 4 of,
Mr. Chaudhary had filed affidavit,
yes, yes.
when?
On 15 February 23,
Your response number,
response number 5, my lord.
15 February.
Yes.
20,
23, my
and your affidavit is response number 2. Mr. Chakraborty for,
Lordship, 24/12/22,
there were 2 affidavits filed.
lordship.
One is Sanjeev Kumar Sharma. At ADC,
Sanjay Kumar
3 and
Sharma,
4,
lordship.
3 and 4 years. What have you stated?
And para 4 of our affidavit in
This is
opposition,
what-
may I read, lordship?
Just filed before the- before 20, 3 years.
24/12, lordship.
No, it's filed on February. It was, the notary was down on 21/12. But it was the actual filing is of 10th of February or something.
No.
Doesn't matter.
No.
Tell us,
Lordship, in our affidavit in opposition, para 4, lordship, the deponent beg to state that as per the district ministerial establishment service rules 1967, year means the English calendar year. In the amendment rule 2015, white notification dated 15/10/15, lordship, it has been reflected that provided 1 year of the joining shall be treated as complete year,
Yes.
irrespective of the date and month of his her joining during year. As such, the consideration of 2007 as a whole year of for respondent number 5, that is Ratul Talukdar, as a junior government service as a junior assistant in the office of the Deputy Commissioner Baksa on 26/2/7. He had completed 14 years of service in the year 2020, lordship, 2020. However, respondent number 5, R. Talukdar, office of the Deputy Commissioner Baska, was continuing his 15-year service during the January 21, lordship. But in this regard, there is no clear notification and order found whether the English calendar year 2021 will be treated as a one complete year or not. As on 18/1/21, as the last date of submission application for the post of administrative officer
we
Baksa,
have read this.
up to 4 p.m. lordship. It's 15 years lordship as per the advertisement lordship. That's why his name is considered. It is our stand.
And Mr. Bukan for whom?
I'm for 1 and 2, Your Lordship. I filed my affidavit on 1st of December 2022.
Yes.
Yeah, my lord.
Right.
Para 8, I had stated, my lord, that it is admitted that as per concerned service rule, a candidate must at least have 15 years of service experience. But it is not. It was not mentioned in the advertisement, Your Lordship. It was quoted by the establishment, the district, the DC.
It is not mentioned in the date of the application.
Yes, Your Lordship. The mistake was done by the DC establishment. In the rules, it's at least 15 years. So, Lordship, please rule. The post of administrative officer shall be filled by selection from among persons who have at least served at least for 15 years in any deputy commissioner establishment.
Okay,
And-
that is all.
That is all, my lord.
The
And,
advertisement did not mention that it is on the date of the application you have to fulfill 15 years. Then the date of consideration, he has put 15 years. So you have considered.
That was the stand. Actually, they took it because of the fact they might have been a mistake, leave it to your lordship. And what happened? The other part to Ashwin won't come even if they.
Will deliver that. Maybe tomorrow. Well, fix it. For pronounce. Next choice. We'll pronounce the judgment tomorrow. Pronounce in the dictate is judgment tomorrow. Is it?
Well,
Pronouncement will have to be right written and cultured. To the right here. Anyone?
Publish.
Yes, madam. Where are you here? Let's go home.
Lordship, this office note dated 24/8/23 says that unserved notice and ID card has not been received back.
When was it issued?
Oh,
5/9, long time back.
Lordship,
How many respondents?
sole response.
You take press stuff, then we'll send it to the lordship. You are SDF.
Yes, Lordship.
I must SDF and counsel for the petitioner by referring to the office note dated 24/8/2023 has submitted that neither ID card nor unserved notice has been received back regarding service upon the sole response. The notices were issued on 5/9/2020. Consider that the present is a contempt matter. That press step be taken by registered post within 2 days. Full stop. List after 5 weeks along with press service report.
Bless.
Okay. Now, Chapter 15.